confirm that we had the discussion before, and please to grant leave.
Then, thank you. Justices, we've prepared full written argument, and we stand by all the arguments that are contained in our heads of argument. Let me just try and give a roadmap as to how it is we intend to approach the matter. In paragraph 83 of our heads of argument, we suggest that there are two types of orders that should be granted. One is a simple prayer that says the appeal is upheld with costs, including the costs of 2 counsel. And the other is a prayer with 5 subheadings. And for today's purposes, we are only going to ask the court to grant 2.1, 2.4, and 2.5. And we're going to submit at the end, when it comes to remedy, that 2.2 and 2.3 are not necessary, and we do not move for those orders. The basis of our case is that it is accepted, we submit, that the notion of disguised extradition is unlawful in international law. It violates the Constitution, and we submit that if ever there was a case on the facts for a disguised extradition, this is it. The facts present, we submit, clearly demonstrate that there is or was a disguised extradition, and to demonstrate that, we are going to ask that our argument be divided into 6 chapters. I'll take the court through the chapters after I beg leave to hand up a small bundle of the authorities that I'm going to in particular refer to during my argument. It is something that we debated in chambers, and perhaps then we will see the 6 chapters divided into the contents page of these further submissions. We've prepared it just to make things easier. There's one case in this little bundle which is not referred to in our heads of argument, and I'll explain why. It's a case dealing with remedy, which only arose after our learned friends' heads of argument were filed. And I'll explain how it came about that that case is of relevance today. But the court will see this, in the bundle there are 5 headings. One sees the rule of law and public opinion. Those are items 1 to 3. Then the importance of extradition and the distinction between deportation and extradition, and there are 3 items. Then a pleadings chapter, and the last is a remedy chapter. Those are the 5 headings. There's one other heading, perhaps I should just highlight, which we haven't included in this bundle as a separate chapter, but that's on the question of waiver or the consent to extradition. But for purposes of that chapter, included in the bundle is the Muhammad case, which is item 4, which is pages 14 to 20. And in particular on page 18, there is a paragraph in the judgment of the Constitutional Court, it's paragraph 64, which we submit should dominate this court's thinking when it comes to the question of was there consent by the appellant to be, and I use the word very carefully and very specifically, handed over to the South African government. Handed over. On the same day, a notice of prohibition was signed, and she says, it's not contested, that she saw it for the first time, that she saw the prohibited immigrant's notice for the first time when it was filed as part of the papers in this case. There's no suggestion that it was given to her, that she saw it, that she knew her rights. There's none of those issues. The simple issue that they raise is on the papers, which I'll come to when I deal with that chapter. So let me turn to the first chapter, which is the rule of law and public opinion. We submit that in this case, our experience tells us that there's an elephant in this room. And the elephant is that the appellant did a bad thing. She committed a serious crime and she must pay for it. That's public opinion. It's hard to find anybody, not that I live in the Twitter sphere or the X sphere, where one looks at the News 24 comments on, there's an article on TV or the news, and then one sees people comment. And almost unanimously, the people say, she must do the time that she deserves. And that's what we would call the public opinion balancing. On the other hand is, what is the law? What is the rule of law? What does it mean? And should the rule of law bend to what the public think should happen? And we have in our bundle 3 little extracts. And the first is the first case of the Constitutional Court, S versus Makwanyani, where there's a heading, the public opinion. It's on page 2, and perhaps I should just take the court through these various headings. And the Jaskelson P deals with public opinion. And he says the Attorney General argued that it was cruel, inhuman, or degrading depends to a large extent upon contemporary attitudes within society, and that South African society does not, etc. And we emphasize what is said in paragraph 88 and 89. Public opinion may have some relevance, but in itself is no substitute for the duty vested in the courts to interpret the Constitution and to uphold its provisions without fear or favor. If public opinion were to be decisive, there'd be no need for constitutional adjudication. Then I go on a little bit lower at letter E. The very reason for establishing the new legal order and for vesting the power of judicial review of all legislation in the courts was to protect the rights of minorities and others who cannot protect theirs. And then the important 2 sentences. Those who are entitled to claim this protection include the social outcasts and marginalized people of our society. And then the sentence which would always dominate thinking in a case dealing with crime. It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected. Let me emphasize, there must be a willingness by the courts to protect the worst, the bad criminals of society. There needs to be protection, and the weakest amongst us, that all of us can be secure. And then on to the next page, in paragraph 89, there's further dealing with this question of public opinion. I do want to jump forward to the case of West Virginia State Board versus the quote from that case versus Barnett, where Justice Jackson said the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, etc., etc. Our rights may not be submitted to vote, they depend on the outcome of no elections. And we know we're living in a world where elections play an increasingly dominant role in the public space. And especially in this time, with elections playing the role that they do, throughout the world, in every country, it's so important that courts ignore that which public opinion should dominate. And we move on to the next case that we, in this little bundle. It's a case called Tsebe, which the court will have regard to not only for the proposition of this public opinion elephant in the room argument, but also when it comes to remedy. And there, the respondents in the Constitutional Court had succeeded in the High Court, but before the full bench, and the Minister of Home Affairs, together with, I think, Justice, argued that they should be deported, or in that case, be allowed to be deported or extradited to Botswana. And there was a problem because Botswana would not give an undertaking of no death penalty. And I remember I was in the case for the respondents, and one of the questions that was posed was, well, you have people who've committed a brutal murder. Whether they're South Africans or not is not an issue. What happens if we say they can't be deported for whatever reasons? And my answer was, which is now contained in the judgment, that's the price we pay as a society for having the rights that we have. And if individuals who've committed brutal murders or committed terrible crimes have to go free. That's the price we pay by having a constitution. And those are the words that then acting Justice Zondo, who became the Chief Justice, now retired, said. Next to between the letters E and F, he said, one of those things that no matter who the person is and no matter what the crime is that he's alleged to have committed, we shall not be in any way party to the punishment, and we will not hand such person over. The path that we as a country have chosen for ourselves is not an easy one. Some of the consequences that may result from our choice are part of the price that we must be prepared to pay as a nation for the advancement of human rights and the creation of the kind of society and world that we may ultimately achieve if we are to abide by the constitutional values that now underpin our new society since the end of apartheid. And we would say this is part of this introductory chapter. Public opinion, there's a law here. And we say, we move on. Just in passing, on the next page, page 8, next to this G, we see that first the alleged killing was brutal. In Botswana, they talk about this. So these are really not good people. And then the next case that we've included is Alvarez Machane, which is referred to in our heads of argument, and it's referred to in the Mohammed case. And we would ask, and this is important from a different perspective. This court knows very well that previously it had ruled in the Ibrahim case in a particular way. And what happened was there was an abduction by the apartheid government of somebody in Swaziland, and this court, overturning the High Court, found that that abduction from Swaziland divested the courts in South Africa of jurisdiction. And you see reference to that case, the Ibrahim case, on page 12. It's reported in April, June, South African law reports. This is on page 12, in the U.S. Supreme Court judgment. And what happened in the U.S. Supreme Court, there were nine justices in the U.S. Supreme Court, and Dr. Alvarez Machane was in Mexico. He was alleged to be part of a drug conspiracy, involved in horrible murders and the like. And the U.S. Drug Enforcement Agency, a U.S. government agency, abducted him into the U.S., and he took the point, I was abducted, disguised extradition, or whatever it was. Therefore, the criminal trial courts in the U.S. don't enjoy jurisdiction. The case went all the way up to the Supreme Court, and there was a 6-3 split. The 6 said, the courts in the U.S. do have jurisdiction. The 3, the dissenting minority, found that the courts in the U.S. would not exercise jurisdiction. And the importance of the dissent, which we would emphasize, are the words that Justice Stevens said dissenting. He says, and starts on page, the dissent starts on page 11, and he says the court's admittedly shocking disdain for customary and conventional international law principles, and he says with reference, is thus entirely supported by case law and commentary. It's not. Then he goes on, syllabus 4. As the court observes at the outset of its opinion, that means the majority. When he talks about the court, he's meaning the 6. There's reason to believe that respondent participated, this is Dr. Alvarez Machane, in an especially brutal murder of an American law enforcement agent. That fact, if true, may explain the executive's intense interest in punishing respondent in our courts. We could almost have that here. That here, the appellant is alleged to have done horrible things. And then he says, if true, it explains why the executive has an intense interest in punishing, in that case, Dr. Machane. Such an explanation, however, provides no justification for disregarding the rule of law that this court has a duty to uphold. That the executive may wish to interpret the treaty to allow for an action that the treaty in no way authorizes should not influence this court's interpretation. Indeed, the desire for revenge exerts a kind of hydraulic pressure before which even well-settled principles of law will, and then see what he said with reference to some other cases. And I turn a bit lower. And here we have, this court should be proud of its legacy. I will come to December, I will come to Mahala. But what the Justice says is this: the significance of this court's precedents is illustrated by a recent decision of the Court of Appeal of the Republic of South Africa. That's this court in Ibrahim. And he says, based largely on the understanding of the import of this court's cases, those were the oldest Supreme Court cases in the US, including our decision in Kerr, and there's a footnote to the Kerr decision. That court, the South African court, held that the prosecution of a defendant kidnapped by agents of South Africa in another country must be dismissed. The Court of Appeal of South Africa, indeed, and this is the important sentence, I suspect most courts throughout the civilized world will be deeply disturbed by the monstrous decision of the court announces today. For every nation that has an interest in preserving the rule of law is affected directly or indirectly by a decision of this character. As Thomas Paine warned, an avidity to punish is always dangerous to liberty because it leads a nation to stretch, to misinterpret, and to misapply even the best of laws. To counter that tendency, he reminds us, he that would make his own liberty secure must guard even his enemy from oppression. For if he violates this duty, he establishes a precedent that will reach to himself. And then I turn to the last case on this point. I welcome questions. Excuse me? Yes. Well, no, Justice Only. We submit that if one turns to this little bundle that I've just given the court, one sees in paragraphs or items 7, 8, and 9, 3 items dealing with pleadings. And we're going to submit, and do submit, that in assessing the facts, there aren't 2 diametrically opposed versions, as your Lordship has put to me. There is a combination of facts that, bearing in mind the onus and bearing in mind various other principles that I will come to, would suggest that the true facts are these. From the 6th of April, she was identified as being, well, on the 6th of April, she was arrested in Tanzania. On the 8th of April, it came to the attention of the South African authorities that those persons, the 2 persons, I think there was a third from Mozambique, who had been arrested in Tanzania, maybe Mr. Bester and the appellant. So on the 9th of April, a delegation of South African officials traveled to Tanzania to determine whether that was true or not. It was Easter, so on Monday, the 10th of April, they had a meeting at the hotel. And various things happened at that meeting, and I'll come to it. But the important is that within 48 hours, she was on a chartered plane having been handed over to South African officials. And the question arises, which is not answered on the papers and not answered in heads of argument. On what legal basis were the police and the Home Affairs officials entitled to leave Lanseria Airport on the 12th, charter a plane, and arrive in Tanzania to do anything? We'll come to what they actually did, but when the South African police's powers end at the border of South Africa. The Department of Home Affairs officials, Mr. Madiri and the others, their power is circumscribed, we know from FedSure, by the law. And this court will have to interrogate, we submit, what powers the police or Home Affairs exercised the moment they left the borders of South Africa on the 12th. And I'm going to invite the police respondents and the NPA to indicate to the court on what legal basis were they there. And they use the word escorting the Department of Home Affairs officials to Tanzania. That's number one. So, yes. Yeah. In the notice of motion, in paragraph 2, we ask for a declarator that the applicant's apprehension, etc., on the 7th, and we do say by the police, sorry, no, we don't say by the police, so that becomes later. Apprehension, arrest, and abduction in Tanzania on the 7th, and subsequent transportation to South Africa and purported arrest and to be declared wrongful and unlawful. Yeah. In paragraph... Yes, 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 no, yeah, I accept that. Yes. Yes. I'm going to come to why I'm going to submit. Yeah, there's been no amendment under Rule 28. No, I accept that. Yes, yes. Well, I'm going to come to it. I'm going to come in the cases. I can't but disagree. I can't but not agree. I agree. I absolutely agree. And that's why we've got some cases on pleadings. No. But in I accept that. I can't but say. I accept that. Well, the police took the point that Home Affairs had not been joined. Yes. 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 Absolutely. Absolutely. Correct. That's what they said. I'm going to come to that, but in order to... Sorry. No, I've got two answers. Firstly, it's not entirely untenable on the facts. We will leave that. But more important... Excuse me? No. The police's version and Home Affairs version is entirely untenable. That's the first proposition. The second proposition, which is where I was going to come to when it comes to the pleadings point, is this. May I ask that the court turn to page 39 of the little bundle? Page 39 of the little bundle. The court will see that that's an extract from a judgment of this court called Jibai. Prior to Jibai, the previous case in the bundle on page 35 is a case called Zealand. But Jibai and Zealand make the same effective proposition, which is on page 39 in paragraph 22. And Justice Gorvin, I must accept that there could be regarded as some type of distinction between the facts in Jibai with these facts. But for purposes of this case, that distinction is without a difference. And what he said next to the letter D, moreover, the respondents alone know the true facts concerning the detention and deportation. The appellants have in their founding affidavit squarely placed the lawfulness of the arrest, detention, and deportation in issue. Now the important sentence, the respondents must therefore prove that they acted unlawfully. So when Justice Gorvin, you put to me, well, what do the founding papers say, and leave it at that. The founding papers say squarely, the respondents, at that time the police, acted unlawfully, I'm in detention unlawfully. That's what they say. And this court is... No. 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 No, with regret. I'm sorry, Justice Gorvin, Justice Rani, because the way we understand Zealand, if a woman makes one sentence in a founding affidavit and says, I am detained unlawfully, and I ask the court to give me relief to be released, as we understand the cases, that's good enough. Now, well, I'm going to come to I haven't been given an opportunity, but I would like to, at some point, forcefully argue that the police had no business being in Tanzania at all. They came into the picture on the 8th of April. Yeah. Well, the 6th of April, the 7th of April, 6th of April. Well, now it turns out it's the Tanzanian police, but she didn't know that, and that's why I keep saying, what Jibai and Zealand and the authorities have always said, she doesn't say, what she says in her founding affidavit is very clear. Yes. Excuse me, that's my point. No. I haven't been given a chance to get that, please. In the founding papers, in paragraph 1, she says, these are her words, presently, I'm illegally detained at Bazaar Makate Correctional Center in Kroonstad. That's what she says. Yes, but I'm going to come... No, I'm going to argue that the facts demonstrate, not just a question of untenability argument, that the facts here show that the police were involved in her arrest on the 12th. No, they're facts. No, Jibai says what Jibai says. I can't move away from Jibai. Jibai says the respondents must therefore prove that they acted lawfully. No, I'm asking you to do what... No, I'm going to ask that the court does what Zealand and Jibai did. Well, not Jibai, but Mr. Rush. Yeah. Whoever. No, no. Sorry, Justice Catherine Sitliani, I think you said something to me. When, it's not a question of justify. The respondents, there's an allegation that the police acted unlawfully here, in this case. And, you know, I accept those difficulties as a matter of principle. I can't run away from them. I can't. But we would submit that, like in Jibai, and let me just go to the pleadings point. No, it wasn't. It was. Jibai. It wasn't. It wasn't. It wasn't. And in the pleadings, what it was said, I just need to find it. In the pleadings, what happened was, Jibai, nobody knew where Jibai was. So Mr. Rashid made the affidavit. And what this court said is it's for the respondents to explain what happened because they are the ones who knew what happened. My client gets arrested. She thinks it's the South African police. She might be completely wrong. And she comes to court and she says, I was arrested by the South African police. It turns out she wasn't arrested by the South African police. She was first arrested by the Tanzanian police. I have to accept that. And then, in Tanzania, on the common cause facts, she was taken into custody, I'll use those words importantly, by South African government officials, including Home Affairs officials, and we're going to submit the police as well. By agreement with the South Africans. So we have an agreement. We don't have to prove that at all. They've proved it themselves. Firstly, we don't have an onus to prove that. That's the first submission I'll make. No, because deportation is a unilateral act, as we know. And the papers make it clear that what happened here was a bilateral act between two states. So on the circumstance of this case, yes, absolutely. Yes? With respect to Justice Mahongo, we know that Mohammed tells us, and the authorities, international law, and always tell us, deportation is destination neutral. And if she could go to China, to Chile, to Cameroon, to any country in the world from Tanzania within 3 days of the 12th of April, by the way, under escort, that's her choice. She had a right. But no, what happened here was the Tanzanians and the South Africans, as you put it, with respect, Justice, colluded, or Justice Catherine put it. Yeah. There was clear. I don't. Near Maring. Yes, they say there was an agreement. This is what they should have done. This is what they should have done under international law, and they should have. Firstly, they should have served the prohibited notice on it. They didn't. They didn't. She didn't even see it. On the 26th of May, 2023, when she saw it when it was attached to the. South African court can rule and must rule that what the South African officials did was unlawful. Yes, sir. Sorry, I understand. Okay, yeah, yeah. No. Yes, no, I accept the question. Accept the question. And so the question has we would submit some difficulties within it. One, if they decided to deport her, that has certain consequences. I'm going to come back to them. But you're asking me the question, they had decided to deport her and they knew that she was facing certain charges in South Africa. Then they had two choices, either to wait for the extradition request and deal with the extradition request as the law provides, and then let an extradition request be processed through the system, through the SADC protocol on extradition, which South Africa and Tanzania are parties to. But if they decided not to do that, in other words, to avoid assisting, and I use the word assisting because that's what extradition is, avoid a bilateral event, they should have, one, served the prohibited immigrants notice on her, on the 12th, but that's when it was issued, they say, and she had 3 days to leave. She could have left and gone anywhere she could have been entitled to go. And the fact that Justice Guthrie, your question actually makes my case. Because you're saying to me, what should they have done now that they knew that there were charges for purpose of deportation? Nothing different as if there weren't charges. That's the point. Excuse me, sorry. Treaty or whatever it is, yes. Yes, yes. No, it's not more legitimate, it's illegitimate on its face. Justice Guthrie, sorry, I do apologize. No, you made a very good point. Your question. No, it's not a point in my favor. It demonstrates exactly what we're arguing. And you asked the question, and the question itself makes our case. And you know what happened on the 10th. You know exactly what happened. The Tanzanians said to South Africa, are you going to bring an extradition request? And what did the South Africans say? It depends on you. It's just unacceptable on any level. And we talk about Olmsted, and they say it was. Yes, of course. Extradition one. Well, maybe or maybe not, but the question is this, that we don't get into that question for a different reason. If they were getting... Sorry, your question is a very good question. Now, and I have to say this because what's being put to me, and it's an important question... No, okay, so the question... Yes, absolutely. Well, we didn't know. That's the Pleadings point. We couldn't have known. We never... Can I just say this? I'm going to come to the Pleadings principles, but I find many... And that point is made, that point is made directly in Muhammad, where it says sometimes they can coincide in effect. And maybe I should read you the paragraph. Where the question is, will you... Sorry, I want to come back to this. It's not, this case, sorry, In Muhammad, what they said was, the court said, deportation and extradition are different. And sometimes they coincide in effect. And in practice, the courts must be careful to determine whether that coincidence crosses the line to become a disguised extradition. That's what, as we understand the principle. Yeah. But your question, that's why your question is so important to me. Yeah, well, your question was so important, Justice Catherine, and I'm not just saying it in my favor, because you said to me, when they were deporting her and they knew that she'd been accused of crimes in South Africa, how would that change the things? It shouldn't have at all. Nothing. And the fact that it was even in their heads is a factor that goes to our case. Let's say, and you asked me, and I haven't answered the question because I haven't been given a chance. What should they have done? And I'm going to answer it like this. Whether they knew or didn't know, whether the appellant or the person was accused of crimes in South Africa or otherwise, what they should have done, he said, here on the 12th of April, whatever time it was of day, here is your prohibited immigrant notice. You have 3 days to leave within 3 days. Full stop. That's what that's what international tells the world must happen when it comes to deportations, Justice Mahmoud. That's how it works. International law says when it comes to deportation, the deporting country, and this is the words of Muhammad, doesn't have any interest in what happens to the person once the person has left their state, rid the country of the alien. So the 3 days off, so she had until the 15th, on any version, the 15th of April, 3 days to leave. But no, South African agents, after an agreement, and we emphasize the word agreement, this court cannot run from the word agreement in the third Secretary of the High Commission's affidavit. There was an agreement. But deportation can never involve agreement between two states, never. And I want to come back to the pleadings point. Excuse me? Sorry. I must for purposes of the pleadings. That's what the pleadings say. Yes. I can't, I run from it. Paragraph 7 of the pleading. So it's page 7, paragraph 7. Justice Gorman, sorry, it answers your question if one has regard to what this court said in Jibhai. We're going to submit on the 12th. No, on the 12th it happened. It happened. In the reply, well, we don't say that. That's what they say. They make out our case.
Your case must be made out of the filing papers, and those are the pleadings. That's the course of the action. And that's what you bring to court on.
Yes. Now, I was on page 39 of Jibhai. With respect, may I please? I know. Sorry, I was answering you, Justice Gorman, and then I was pulled back to the Justice.
I must just say, I don't have any difficulty with that deportation is an act of neutrality in the sense that you say all that you require to do is leave my country.
No.
I also don't have any difficulty with the Tanzanian police, if it was there, arresting her for being an illegal immigrant in their country. I'm pretty sure you can't have a problem with that. And then deciding at some stage, whatever stage, to issue a deportation order. If that order then says, you've got 3 days, you've got 3 days.
Yeah.
So That's where we've got so far in terms of any deportation.
The pleadings
said that does not give any rights necessarily to foreign authority to come to that country without consent. That's where we might get to if
we get there.
The argument succeeds further down the line than I'm going at this stage. I have no difficulty that unless there is consent to say, well, I'd like to travel home with you, whatever it might be.
That consent, yes.
Yeah, correct. Then the foreign authority, in the light of a deportation order from another country, has no rights.
So if there's a deportation, if I understand the question.
So Tanzania issues a deportation order that does not authorise any foreign country to do anything without someone else's consent, without the person's consent.
No, I go further than that. First, the answer is yes, but there was no consent here, but that's it. We'll get to that argument. But more importantly, even if the person consents, that doesn't turn the conduct of the foreign authorities on that sovereign state's land into a lawful, authorised act conduct.
No, but if someone arrives and says, I'll transport you home, yes please. I mean, that's as simple as that.
Someone,
let's just say someone.
No.
If someone arrives and says, I'm prepared to transport you home, would you like to come with me? And you say yes. That's not any disguised extradition at that point, is it?
Well, I'm going to disagree. I'm going to say it's unlawful.
You're entitled to agree to that.
No, I don't agree with it. We're welcome to
but
it.
you serve a deportation order, and someone says, well, you've got the order, you've got to leave the country in 3 days, I've got the aeroplane, do you want to jump on with me? I'm not saying those are the facts necessarily. You can't have any argument with that, surely.
I'm going to argue with it. I do have an argument when it comes to the foreign authorities, because the foreign authorities, well, I can't speak for all foreign authorities, but South African authorities. The South African authorities need a legal basis to be able to offer her lift back. And if they don't, the consent is one which is an unlawful consent as a matter of principle. One can't say, well, that's why, Justice Gore, when you said someone, if it was me, and I hired a chartered plane, with my money, with my private jet, or my private, which I could never afford, whatever. The question is, this is South African government doing it. And the South African government needs a source of power. We'll get to that. But I do want to please, I know you pushed me on the pleadings point, and I have to read this one sentence.
Yeah, well, I am pushing you on that point, so I want to give you every opportunity.
And I haven't even, I'm pleased. So in paragraph 22 on page 39 of our little bundle, and I started reading and then I was, it's page 39.
The bundle just the...
Yes, that one. Yes. This is page 39. It's paragraph 22. It's the third sentence after the footnote 10. And I know, Justice Gore, when I had started reading the paragraph, but then I was pulled away. So
well, I think my sister took me.
I'm just making. It's the third sentence, which is the sentence that we would submit, puts a hole in the debate, that puts a cap on the hole that puts a cap on the debate that we've been having. And because every deprivation of liberty is presumptively unlawful, the respondents bear the onus to adduce sufficient facts to justify the actions. And here's the important sentence, which we would submit, puts paid to the difficulty that the Justice Gore, when you identify with me on the pleadings point. This is so also in motion proceeding as an exception to the general rule that the applicant must disclose its case in the founding act.
I have no difficulty with that proposition, but we've still got to prove a deprivation of liberty by the person you accuse of having deprived of liberty. That's what you've got to prove. Before any onus shifts about whether it's justified or lawful or unlawful or whatever else, you've got to prove a deprivation of liberty. Do you not?
She has.
Well, that's for me the $50 million
Well,
question.
let's read the next sentence.
Has she proved a deprivation of liberty by the South African?
No, well, then read the next sentence. There's good reason for this approach. This is the exception to the rule. Especially in the present case where a person on whose behalf the application was launched is alleged to have been disappeared and unable to oppose an affidavit. Moreover, and this is the important point, moreover, the respondents alone knew the true facts concerning the detention and the deportation.
No, but she
How could she know?
She makes up the case that South African police arrested her Tanzanian soil.
Yes.
She even identifies people.
Yes.
But that case flies in the face of the respondent's version. So I'm talking about the deprivation of liberty now. Forget about the lawfulness or unlawfulness. She's got to show she was deprived of her liberty by the South African police, does she not?
No, I'm answering it like this. Well, because I'm answering it like this. She's got to show that she was deprived of liberty, number one.
Yes.
And she does that. She says so, and there's no dispute. She was arrested in the time frame. She was handed over to the South African authorities in the 12th. It's common.
That's a question in the past. You said that she has shown that she was deprived and
Yes.
put in power.
No, I'm coming to this. She says.
So it's important that we deal with the
Yes, okay. So there are three actors who deprived her. Three. The one was the Tanzanian authorities. I can't get away from that.
She was arrested in Tanzania.
No, we accept that. Okay. Two, the police. And I'll tell you when, I'll say when. And three, Department of Home Affairs.
All right.
Now, the question then becomes this. If I'm right on that, and I accept that if I'm wrong on all that, well then, obviously the appeal can't succeed, obviously.
So the police, whether or not she was deprived of her liberty by the police, you accept that's a factual dispute?
No, I'll explain why. I'm explaining why. The police say the following, and I need to turn to what they say and what the pleadings will say. The police say the following.
Just refer us.
The police say that they didn't have any role in her handing over, and they were only there to escort the DHA.
Yes.
That's what they say. Then the DHA filed an affidavit, in a sense, not inconsistent with it, but the basis upon which they say they acted, which includes the police, will demonstrate, we submit, that the only tenable version that can be accepted is the police were party to, and this is why I kept in 2.1 of the heads of argument prayer, the police, because we could have taken it and said just Home Affairs, but the police were there. So on page 141,
Well, that would be faithful to the case you make out of the final page.
no,
The 2.1 involving the police. Not the DHA. Anyway, that's a different issue.
so on page 141,
So let's go there.
141, this is the DA, this is Mr. Matthews' affidavit. This is what he said. And the police can't get away from this, even though this is the version, and it's the only, in view of the reports that Bester orchestrated an audacious prison escape and was regarded as armed and dangerous, this is the Home Affairs, decided to enlist the services of a special task force of the police and officials of correctional services. This was not a foreign concept, full stop. Immigration officers exercise powers when the need arises together with members of SABC. And the question, obviously, that a court will scratch its head about is, well, what authority is for that? And what's the answer in the next paragraph? And I'm going to take the court to that provision. In fact, Section 41 of the Immigration Act places the responsibility of performing statutory functions and powers on both the immigration officers and members of the SABC. Section 41. I would like the court to read it, paragraph 53.10 of our heads of argument. And there are two problems with it. And I say deep problems. The one is, South African legislation, unless expressly provided, this is the three problems actually. The first is, South African laws, unless expressly provided within the law, doesn't have extraterritorial application. That's problem number one. Problem number two, the section itself is contrary to anything that Home Affairs could possibly have done in Tanzania, because it talks to certain conduct in South Africa as principle. And three, it sucks the police into their difficulty. Because
I have no difficulty with the fact that they weren't authorized. They could not be by Section 41 or anything else to do anything
No,
in Tanzania.
but and the police, sorry.
But you've got to show that the police arrested on Tanzanian soil. In other words, deprive her of her liberty. The police.
Well, I'm just getting.
The police.
No,
I see that.
No, I accept that. So the police were there to escort.
I don't see any proof on the respondent's version that the police arrested her on Tanzanian soil, and that's the case you make out for example. And that's where there's a factual dispute, and if there's a factual dispute, it must be resolved in favour of the respondent.
No, I'm going to come to that. I need to come to that, please. But before I get to that,
Arising from my brother's question, you refer us to paragraph 22 of 141.
yes.
The involvement of the police, that is in relation to Esther.
So excuse me.
You need to read paragraph 22 correctly. Because I say the view that the pastor Esther was faithful, which has in this case,
Yes.
and was regarded as armed and dangerous, I decided that this services circumcision as possible of the
That's correct. That's
so that allegation is made in relation to that. What did they do in relation to?
No. So what happens is this. Thank you. But the next paragraph then explains. Sorry. And I need to. This is a nuance point, and it might be difficult, but I need to explain it. When Home Affairs acted as they did, they enlisted the services of the police to, on the police's version, to escort Home Affairs. That's what the police say. And the police say they had nothing to do with it, in the true sense. That's what they say. But at the airport, when the third secretary recalled that the Tanzanian authorities handed over the appellant to Mr. Matthews, I presume, or Home Affairs, and sorry, I got that wrong. The Tanzanians handed over the appellant to Ms. Moreng. Ms. Moreng then handed over the appellant to Mr. Matthews. When Mr. Matthews received the appellant, he did so with the police around him. That's what he said, simply put. And the question then arises, what were the police doing there?
She wasn't handed over alone. It was Mr. Best as well.
There could be, we don't know. We don't really, what they say, but the point is these facts and what time it was, how it was, are all within their knowledge. And they're cryptic about it. But I will come to the pleadings point about.
But are you saying that the DHA was impermissible for them to draw in the help of the police
Yes.
to escort
Yes.
the appellant and Mr. Bester back to the country?
I'm going to invite Mr. Stellenberg to indicate on what basis the police were in Tanzania. I can't be invited by him. Let's say I travel to Tanzania tomorrow, me. And I'm scared because there's somebody that wants me there. I can't enlist the South African police to come and assist me. On what basis could
Yes,
it?
but that's not your case. You're saying that she was unlawfully abducted
No.
and arrested. I mean, so
It
even
is.
if they were there unlawfully,
Yes.
but they never do the arrest.
So what were they doing?
Well, they were there to escort her back. There's a whole big difference between escorting and arresting.
I hope.
There's nowhere in the papers that appears that she was arrested by the South African police.
No, let's accept, for purpose of the debate, that she was arrested by Home Affairs at the airport.
Well, she wasn't even arrested by Home Affairs. She was handed over to the High Commission. From the High Commission then handed over to Home Affairs. But she was arrested by the Tanzanian authorities.
Sorry, I have to say, I'm going to make
But I
one.
thought you accepted that earlier on.
No,
And I
I'm
have to
making the point that you made the
that
point,
she was-
Justice Catherine, that she was never arrested by Home Affairs, she was just handed over to them. Huh? We would sit on that.
Well, they transported her back to South Africa. The police escorted her.
What happens if she said, no,
So
I
what,
want
there
to
was
go
an
to
arrest and another arrest and another arrest.
No. There was.
That's what we're trying to understand.
No.
When did the arrest take place?
There are 3 arrests. The one arrest is when she by the Tanzanian authorities.
Okay.
That's the original arrest.
There are 3 arrests.
There are 3 arrests, yes.
The first one is
The 6th of April by the Tanzanian authorities. The second one is on the 12th of April under what Home Affairs. May I read section 41? The second one is a section 41 arrest. A section 41 arrest late in the evening of the 12th of April. And then the third arrest is at Lancero by what the police say is a section 43 warrant execution.
I accept that they thought they had the authority, and I accept that they didn't have the authority.
To do what, Justice?
To do anything on Tanzanian soil without her consent.
Let's
go that far.
no, but it goes deeper than that. Please, I need to say that. Section 41 speaks to certain powers which they say they exercise.
Oh, no,
But let's see what those powers are. No, but what are those powers that they say they exercise? You've got to look at what. Let's read it. That's the point. The important words in Section 41, which we submit, should dominate how the court views what Home Affairs say they do. This is what it says. This is what they say. It's not like we don't even, I mean, the Jimite point, how could they know? They know, we don't know. When so requested, this is paragraph 53.10 of IAS. When so requested by an immigration officer or a police officer, any person who shall identify himself or herself as a citizen, permanent resident, or foreigner, and if on reasonable grounds such immigration officer or police officer is not satisfied that such person, we've underlined and bolded the words, is entitled to be in the Republic. That just shows that Section 41 had no application. But leave aside that for a moment. I want to go further. I want to please, this is important. Then, so they ask the person for their identity. They then can interview the person, which was not necessary here because they knew who they were dealing with. What may they then do? And this is what they say they did. They say such immigration officer or police officer may, and Justice Caffrey, we would disagree with you if you say that this is not arresting, take such person into custody.
But that's an illegal immigrant into South Africa.
No. You're interpreting Section 41 no, it's an illegal immigrant in South Africa. Correct. But they say that that's what they did.
No, we're wrong.
No.
They misconceive their powers in terms of
No, they misconceive their powers, but in misconceiving their powers, the power that they were misconceiving, they thought, absolutely wrongly, on a range of levels, that what they were doing was taking such person into custody.
And if, in fact, she turned around and said, I refuse to go with you,
Yes.
they would have had to release her because they had no power. They might have thought they didn't have to release her, but they would have had to. But now this is another thing we talked about. We've still got to get back to the police.
And what are the police doing then?
The police are standing by and saying, well, here we are.
Justice Gordon,
No evidence that the police were involved at all in any of that unlawful conduct.
let me answer it like this. I'll answer it in two ways. Firstly, if the court is inclined to take the view that the police could just stand on the side around Home Affairs, here we are, and suggest that that has got nothing to do with the taking into custody of the appellant, we say that's not the world that we suspect court should go to.
Well, except Mr. Best is there, you see. That's why Home Affairs have taken him. Casey gaps it.
In case took the gap.
Casey gaps it. But I mean, the point is, anyway.
No, I want to go further. So that's the first point. That's the first point. The second point on that. The second point, if you are insistent. Oh, sorry.
I just want to be clear in my mind that you say the second arrest took place on the 12th.
Yes.
When she was, in quotes, handed over
Yes.
to Miss Roy.
No. Yes. It's a double barrel because it was.
Yes.
Yes.
So when she was handed over, the mere presence of the police there constituted arrest.
Excuse me.
The mere presence of the police who were escorting Home Affairs people.
Yes. That's what they say.
constituted arrest.
Yes. No. What I say is this: to suggest, I've got two answers. To suggest that the police, as Justice Gordon, could just be walking around saying, here we are, and look at the sun or the moon or whatever, the moon at that time of night, we would submit is an untenable suggestion or finding.
No,
Bearing in mind,
I just want to know exactly what the submission is. That
the police were involved as much as Home Affairs in what happened on the night of the 12th in Tanzania.
she was arrested under those circumstances when she was handed over.
Correct.
She was arrested because the police were there, and it's untenable that they couldn't have been there just to walk around.
As it pleases the court. And if you reject that submission,
on South African soil.
excuse me,
The third arrest was there on South African.
the third arrest was in Lancero. if you reject the submission as far as the police are concerned, and you can, and the court finds that the suggestion of Justice Gorgon that the police were just looking around and waiting for action to happen, then
We don't know any different, maybe.
they haven't told us.
No, well, we don't know.
Yes, because
she
they
didn't
don't-
say anything. That's what we believe, because what she said was wrong.
I'll come to that. I will, Justice Gorgon, I will come. See, I haven't been, when I come to my pleadings argument, I'll deal with it. But if you reject it, even with after my pleadings argument, then I would ask that the court take out the 3 words in the second line of 2.1 of our order. So paragraph in our order 2.1. But we said I'm not going to concede this at all. I will
Sorry, in your order as per your heads of argument.
as the heads of argument. So it's on page 14, paragraph 2.1. There's a declarator, and the second line includes.
Fast.
Give us a second, please.
Excuse me. Sorry.
Which 3 words did you take out? I think you
Of the second and.
You need this second.
The second and, of those 3 words. Sorry, the second line on 2.1.
Oh, so the and,
The second and.
yeah.
Because then the court would be giving our learned friends a free pass. There's nobody to defend the Home Affairs here.
Okay, so
Well, they were to the frame, but we get into the pleading argument.
Yes.
No,
But I'm going to say the police are in the frame, but we'll come to that.
Sorry, I'm confused. Which second and? So the,
No, 2.1, the second line,
Yeah.
it starts with the word officials,
Yeah.
and then you take out the words the, second, and.
oh, take that.
Those 3 words out. That's if you reject my argument as far as the involvement of the police.
So then your case would be she was apprehended and arrested by a police.
I'm not saying that's our case. I'm saying if the court rejects my suggestion that the police were involved, then my submission is the court should nevertheless find that Home Affairs acted in the way that's described in paragraph
Home
2.1.
Affairs would have apprehended her and arrested her.
Yes. That's if you reject my argument.
Basically, your case is that the Home Affairs was involved in the second arrest, not the third.
Not the third.
Not the third. It's not when she gave herself. Not when she was.
But it's hard to say. The evidence is that there was a section 43 of the Criminal Procedure Act warrant, which was waiting for it, had been issued in, I think, on the 6th of April. I think it's the 6th of April. And that it was executed when she arrived at Lanseria, and presumably those in whose custody she was handed it over once again to have that warrant executed. Who executed it, I presume?
Well, the Home Affairs had no jurisdiction to do that anyway.
No, I've neither here nor there. But now please turn to the pleadings point, Justice Gorgon. I think that does exercise my mind, because a lot of the debate has surrounded this question.
All right, can you sit because of dinner for about 5 minutes? Yeah.
Oh, now continue.
Yeah.
The pleadings point, I want to make a number of submissions. The first is, Justice Gorgon, you accepted it seems to me that it was accepted my proposition that in a case such as this, well, I'm not sure you did accept the proposition, but my submission is, in a case such as this, somebody who claims to have been in unlawful detention, and she chooses the wrong target as to who it is, can't blame her because she wouldn't know.
Okay, no,
But I'll come to.
I'll tell you what my understanding is this. Once you have proved a deprivation of liberty by that person you accused of having deprived of liberty, the onus shifts to prove the lawfulness of that deprivation to that person. But you first have to prove a deprivation of liberty.
I'm going to qualify what, if I understand your position, Justice Gorgon, to say what's got to be proven by the applicant is that there's a deprivation of liberty.
Yes.
If she chooses the wrong target, who did it and the wrong date, that's for the respondent to say, it wasn't me, it was somebody else on a different date. But she says it was the police, she's wrong, so we accept that she's wrong. And then the court will do the following. This court and many courts have made this following point on page 44 of the little bundle. Have made this point. That in a case, generally, not in a case such as this, a general case, it can be a review, it could be an interdict of any kind where certain things are said in the replying affidavit. Let me emphasize this. Certain things are said in the replying affidavit. And the respondent normally would not have an opportunity to deal with that which is contained in the reply. But what is said in the reply calls for an answer, and there is no request by the respondent to deal with it, then the court will accept as a fact what's contained in the replying affidavit. This court has said it, and many courts, and it's very neatly summarized in paragraph 51 on page 44 by Murphy J. As these averments were made in the replying affidavit, the second respondent, strictly speaking, had no entitlement to respond, and the normal course they could be denied or explained by the respondent. Nevertheless, if the allegations by Ms. Peer were untrue, or if an adequate explanation were possible, leave of the court could, and we emphasize should, have been sought to answer them. See Sigaba. The respondents did not require to be given an opportunity to deal with these averments. Their failure to do so tilts the probabilities. That's paragraph 51, and the same proposition is in 71, paragraph 71 on the next page. And then if we turn to page 48, this court, Scutts JA, said in Pretoria, Portland Cement, and it's been repeated, this proposition in a minority of Justice Nkobo in the Constitutional Court judgment of fraternity. But it's a principle that we submit should commend itself to this court generally, and in particular when it comes to the questions of unlawful deportation, unlawful disguised extradition type case. It's classically the kind of case that this kind of idea deals with. What he said in paragraph 63 on page 48, the court will know what happened here was there was a raid on Pretoria Portland Cement Company by the Competition Commission, and the commissioner was Advocate Similani, and he said certain things and did certain things, and in the replying affidavit then there were certain allegations made by the attorney for Pretoria Portland Cement, and this is what Scutts J.A. said. The impression of publicity seeking is then reinforced by Similani's uninvited media interviews held in PPC's own car park. There's another aspect of this conduct that deserves comment, and here we come. In his replying affidavit, Gomersal stated that the book kept at the entrance gate reflected that at 12:40, Similani had signed and stated whom visited MD. Gomersal added that it was simply untrue. I just want to emphasize, in our replying affidavit, we look at what the respondents say and we say it was simply untrue, and then it goes on for Similani to have said that he intended visiting the managing director. And we know from one of the commission's witnesses that the meeting in the car park was prearranged. Now this is the sentence that we would commend to this court. Now it is true that Similani had no right or duty to answer this allegation made in reply. But Scutts J.A. says, I would have expected him to offer to do so if Gomersal's imputation of dishonesty were false. So what happens here is we say what we say in our founding papers. I cannot get away from Justice Corbyn. They put up a version, they being the police and Home Affairs. In our replying affidavit, we say, hey, look at what they say. This is an unlawful disguised extradition. I've never seen my prohibited immigrant paper, etc., etc. And what do we hear in response to the reply? Nothing. And we submit that this court should say, as Scutts J.A. said, yes, the response had no right or duty to answer, but this court would have expected the police and Home Affairs to offer an explanation if the dishonest disguised extradition suggestions were untrue, were false.
The difficulty with that, though, is that both of the cases you referred to us were evidentiary issues which should have been dealt with. In other words, the person should have said factually this or that or whatever. What you're attempting to do is found your case on the answering affidavit and then in the reply say, oh, well, but actually that's a disguised extradition. And I don't think that's on the same footing as these matters.
Justice Corbyn, I know that my learned friend will try to argue till it's signed, and I've got two answers to that. That's the kind of idea that I'm hearing from you, Justice Corbyn. We submit that Teletsani itself, the ratio in Teletsani, the kind of dicta that follow the ratio, supports us rather than on this argument that I'm now making. And that I ask that the court have regard to what Buerta J.A. said It's 197 from E onto the next page. I'm not going to read it now. 198. That's one.
Are you referring us to which case?
Teletsani.
Teletsani.
And there's another case.
All right, with that, can we just take it?
Yes, please. Yes, yes, yes.
Pretty much.
As a please.
Yes, Mr. Kath.
Thank you, Justice.
You were all still on Telesane's case.
And I think as I was talking about Teletsani, Justin Gorman suggested to me, well, we only get to the Teletsani kind of debate if we make out a case in our founding papers. And I want to I have to touch upon that because that's been the sort of the golden thread of the debate this morning in many ways. I want to make three important submissions in this regard. The first is, pleadings are there to protect parties having the opportunity to have a fair trial. That's the key reason for pleadings. And if the pleadings arrive at a court in completeness, in a manner in which there can be suggested to be no unfairness, then there can't be a complaint that the case wasn't made out in your answering affidavit or your funding as a matter of general principle. That's as a matter of general principle. Number two, especially in a case involving the liberty and the deprivation of liberty in general of someone, the general rules concerning making out a case in a founding paper and then not amending, etc., are to be considered to be somewhat watered down or accepted as I read to the court from Jibai. And number three, I do want to touch upon, which I have to do, what is stated in Zealand, because the Constitutional Court then said effectively what I've been arguing the whole morning concerning the pleadings point. I've got other pleadings points, but on this point. On page 36 of the small bundle, there's a paragraph 24, which says, and this is Langer, CJ, the Chief Justice, there's another more important reason why this court should rule in the applicant's favour. The Constitution enshrines the right to freedom and security of the person, including the right not to be deprived of freedom arbitrarily, etc. Accordingly, and I want to read from here, accordingly, it was sufficient in this case for the applicant simply to plead that he was unlawfully detained. This he did. The respondents then bore the burden to justify the deprivation of liberty, whatever form it may have taken. 25. This is not something new in our law. It has long been firmly established in our common law that every interference with physical liberty is prima facie unlawful. Thus, once the claimant establishes that the interference has occurred, the burden falls upon the person causing it. In Minister van Wet en Orde versus Mochaba, the Supreme Court of Appeal again affirmed that principle and then went on to consider exactly what must be averred by an applicant complaining of unlawful detention. In the absence of any significant South African authority, Groskopf J.A. found the law concerning the raven dicartia a useful analogy. The simple averment of the plaintiff's ownership and the fact that he or her property is held by the defendant was sufficient. This led that court to conclude that since the common law right to personal freedom was far more fundamental than ownership, it must be sufficient for a plaintiff who is in detention simply to plead that he or she is being held by the defendant. The onus justifying the detention then rests upon the defendant. There can be no doubt that this reasoning applies with equal, if not greater force under the Constitution. And here's the important paragraph. Even if the applicant be said to have altered his cause of action. That's how, Justice Gore, when you started with me this morning, there was no Rule 28 amendment. Even if that is so, which I do not accept to be the case, irrelevant, no prejudice will be suffered by the respondents if this court decides the case as it has now been presented. There's no prejudice. Nobody suggested any. Our learned friends' heads of argument don't suggest so. And as a matter of objective fact, there can be no prejudice. They've put before the court that which they wish to. They complained about urgency, they complained about joinder, all of those issues have now water under the bridge. And then it goes on. That is so because the question of the lawfulness of the detention is in the maximum security was canvassed both before that court, the High Court and the Supreme Court of Appeal, and there's sufficient evidence between this court properly to decide the case. We're in that territory. And we submit that on the pleaded facts, and when I say pleaded facts, that includes a reply which hasn't been answered, which hasn't been responded to. And if one takes the reply, I'm not going to read it, but I do just want to highlight the kinds of gomosal kinds of suggestions that are in the reply. And it will be demonstrated, we would submit, that these averments in the reply called for an answer. So on page 2110, it starts, page 211, 8.1, this application does not concern what happened in Tanzania. It does concern the lawfulness of South Africa's conduct in Tanzania. The Constitution requires that the respondents act in a manner that is lawful and consistent with their constitutional obligations, both domestically and internationally. And we know that's true from Kaunda. Then the next paragraph, and this is not responded to. So when we take the Zealand, Scuts, JA, and PPC kind of ideas with Tantush, this we would submit called for an answer. On the respondent's own version, they have not done so. That is not acted constitutionally. It is clear from their answering affidavits they colluded with the authorities in Tanzania to secure my forceful return to South Africa in order to evade the extradition procedures provided for in the protocol. Indeed, respondent DHA makes it clear that there was an agreement between Tanzania and South Africa for my deportation. And this feeds in with respect to Justice Catherine Siciliani's idea. Was there collusion? Of course there was collusion, as a matter of fact. But it said so and it's not responded to. Paragraph 8.4. The decision by the South Africans to seek the extradition does not lie with any... Remember what happened here was the South Africans said to Tanzania, what do you want us to do? Should we bring in extradition? That demonstrates what is actually happening here. The South Africans justifiably, and I'll come back to it, wanted Bester and the appellant back in South Africa quickly. They know, as we all know, extradition takes time. There's questions of admissibility, there's questions of every, what some would say, stone trick in the book. We've all been down that road many times. So what did they do? They avoided their right, and we would submit obligation, and we would, under international, to use the SADC protocol on extradition to achieve that which they wanted. Bester and the appellant back in South African soil, arrested under the Section 43 warrant. That's what they did. There can be no doubt about it. And that is what he said in 8.4. But the decision by the South Africans to seek the extradition of an individual does not lie with any country. It lies only with South Africa. They did not need permission of or direction from Tanzania to nudge to follow the lawful extradition procedures provided for by the protocol. They were required to do so because that is the lawful mechanism for the return of sought persons to South Africa. Extradition disguised as deportation is not a lawful mechanism. It is inconsistent with both the Constitution and international. Let me just stop and remind the court what I started off in the beginning by saying, where there is serious crime, brutal murders, and what happened in this case could be regarded as a serious crime, there is a deep temptation to, as Chaskelson P. put it in Makunyani, or no, it was, yes, to use questionable methods on the war on crime. That's what happened here. It cannot be denied. There were questionable methods used outside the realm of the extradition protocol, the SADC protocol on extradition. Paragraph 8.5. Secondly, the respondents have not discharged the onus. The evidence of the respondent is contradictory. On their version, the relief sought falls to be granted as examples, and there's a whole series of examples. And for example, 8.5.2, next to the letter 8, line 18. They exercised control over me. I was not free to determine my own movement because they did so. The DHA respondent's version is fatally defective because South Africa's laws, etc., etc. So here the question is, was she free? She says she wasn't. And there's no comeback to that as a matter of pleading.
How does she respond to the issue of consent?
Consent. She says she didn't. But perhaps that's my next chapter.
Yeah, because you didn't
My next chapter. Consent constitutes a waiver of rights, if we understand it. And our learned friends have launched, or the police have launched an application to bring in the bail, what she said in the bail affidavit, to try to show that she waived her right to extradition, she consented. May I ask the court to turn to bundle page 18, small bundle page 18. This is paragraph 64. The onus to prove such waivers on the government. So Blanche and Christians allege Mohammed freely, if not eagerly, chose to go to New York in the custody of the FBI agents. Shabiri says, well, and we know, he says it in 2 paragraphs. This is the police defending Home Affairs. He says, and this is the high water mark of the point. I'll just find it. Yes, it's pages 63 and 64. This is the high water mark of the waiver consent argument.
63 and 64.
63, paragraph 78.8, together with 78.9. That's the high water mark of the waiver argument by the respondent. By the police respondents, not by Home Affairs, by the police respondents. And the court will look at these 2 paragraphs and determine whether that which is set out in Muhammad in paragraph 64 was satisfied. So what Muhammad says, the onus to prove is on the government. To Blanche and Christian says that Muhammad was freely, if not eagerly, chose to go to New York. Muhammad flatly denied it, as does the appellant. So direct and one-dimensional, a dispute of fact cannot really be resolved on the affidavit, nor is it possible to ascertain a clear preponderance or probabilities in favour of the government version. Although a show of bravado, and remember what Muhammad did was he blew up a whole bunch of people in Tanzania in the war against the West, Al-Qaeda, Osama bin Laden type issues. And the argument could be by Mr. Blanche and Mr. Christians from Cape Town, there were immigration officers who hoodwinked Mr. Muhammad to go in. It's in the papers that he was a burger flipper at Burger King somewhere in the suburbs of Cape Town, and he'd applied for asylum because he said he was from somewhere in East Africa, and he had to go and renew his asylum permit, and he walked into the Home Affairs offices, and they said, come with us into the lift, down the lift into a waiting car, and the next thing he was on a plane to the United States. And of course it dealt with the death penalty, but the point is, although a show of bravado, so the issue is that, maybe he wants to go to New York, face this trial because his show of bravado with his fired by his religious fervor could explain why he would have opted for New York. It does remain curious that he'd willingly put his life in jeopardy. Nevertheless, notwithstanding this, we will assume in favour of the government that its factual version has been sufficiently established. This would still not assist for 2 reasons. Now the important aspects. First, none of the government opponents even suggests that Muhammad was aware of his crucial rights to demand this protection against exposure. Indeed, there's no suggestion that the South African government's officials concerned told him what he could do. Paragraph 66, in the second place, is a profoundly disturbing circumstance that on the government's own version, Muhammad was no time afforded the benefit of consulting a lawyer, etc., etc. Now the question arises on the papers, where does one find any suggestion that the appellant knew that she had a right to contest extradition, knew that she had a right to be escorted out of Tanzania 3 days after the 12th of April? Nowhere. And Justice Catherine recently, you asked the question, what should they have done? They should have read her and told her, these are your rights. If you are going to be sent to South Africa by a chartered plane by the South African authorities, you have the right to contest that, because that would be an extradition. And there are extradition laws, there's an extradition treaty, and therefore it would not, your so-called waiver of consent to deportation would run into the difficulty
You
that
mean
it's
to
not a true
extradition?
one. I just want to make one point on this
You
aspect.
mean
Well, you have a right to
consent
hearing
to
first.
extradition, not to deportation.
To extradition.
Consent to extradition.
No, she would have a right to...
Or consent to deportation, what do you say?
She would have a right to an extradition hearing, which she may or may not consent to.
No, so in other words, that she need to be informed that she could or needn't consent to extradition. You said to deportation.
No.
Deportation is a unilateral act by somebody else.
But the point is, she would need to be told a number of things. One is that she had a right...
No, I understand the point, but it relates to extradition, not deportation.
Well, deportation as well, and that's the point I'm coming to. She should have been told, which she wasn't, that in the deportation context, leave aside the extradition context, she had a right to leave Tanzania 3 days after the 12th of April. She was never told that.
Well, that would have been in the prohibited person notice.
If she only saw that for the first time on the 26th of May.
Yeah.
No, she says in terms, not denied, that she saw that document on the first time. And
in May.
In May, 26th of May. And interestingly, and I know I don't want to... If one turns to the founding papers, and you see her affidavit ends, I mean, I know this is something I've argued.
So
Shouldn't
now,
be doing what I'm not gonna-
are you leaving this point now, deportation, because you said that Tanzanian authorities should have informed her that she had the right to leave Tanzania in 3 days' time. Any other thing that you wanted to
I make 2 points about the... Well,
Yes.
there's one big point, which
Yes.
is she wasn't informed of any of her rights.
She wasn't informed?
Of any of her rights. No. Okay.
But assuming they knew that she was going to be facing prosecution, which she knew, I think it's common cause that they were quite aware that she was
Let's
going to be
assume
facing.
that.
So could they have still carried out the deportation on the grounds that she was a private person, but say to her there's a possibility that you're going to be facing prosecution and these are your rights in respect to that. You're entitled to an extradition hearing. No, well, that's gone because she's already gone across. It makes no sense anymore.
The
But
point
that
is,
makes no sense anymore.
on the 12th, when what they should have done to come home on
Well,
this
for
way-
purpose, because now she's deported, right? And then she also consented, presuming, well, the state's case is that she also consented
Those
to
two
going
par-
back to South Africa.
Those are the two paragraphs which I've read to you.
Yes. So purposes of consent in relation to the deportation, what should she have been told?
I was coming to that.
Okay.
They should have, that's what I'd say. Leave aside extradition. So
Yeah,
let's
forget
assume
about
this-
that.
They should have at least told her in the first instance that she had 3 days to leave. They didn't tell her that.
Here we're talking about Tanzanian authorities.
Yeah.
We're talking
Yes.
about Tanzanian authorities.
Yes, but we know why the Tanzanian authorities did that is because they were in collusion with the South African
No, I
authorities.
just want to establish whether we're talking about Tanzanian authorities.
Yes, no, but Justice Catherine is asking me what should have happened in the context of her... No. The police say, not Home Affairs, that she waived her right to contest whatever she was facing. That's the argument by the police. Our counter to that is she did not waive, she did not consent.
Mr. Katz, all I want to establish from you is we're talking about the authorities in Tanzania here. When you say they should have told her this, they should have done this, we're talking about the authorities in Tanzania.
Maybe the South African authorities as well. I'm not commenting on just this. It doesn't matter. If the South African authorities wanted her, then she should have been told of her rights, whether it be deportation, extradition, or otherwise. And that includes South Africa. Not just it's a unilateral act of deportation, I accept that. But then the question is, it's not my case that there was a waiver. It's not my case, it's the police's case. And I'm now saying to the court, there was no waiver of deportation, extradition, anything. And now the question is, well, what should have been done to achieve a waiver or consent? And I'm answering it by saying she should have been told the following rights by whomsoever. And especially, for example, your Justice Makoko, you make the point, by the Tanzanian authorities and the South African authorities on the night of the 12th of April. They were the ones taking her. They say it's a deportation. They should have said to her, look, you're being deported on the basis of this notice that was issued this morning. Have you seen it? And do you know that you've got 3 days to leave Tanzania and you don't have to come to South Africa? That's what the South African authorities should have told her.
Was that all they had to tell her?
Excuse me?
Was that all they had to tell her?
Well, in extradition, there's a lot more they should have told her. But I don't want to make a suggestion.
No, because here you're presuming the deportation Well, I mean, presuming there was deportation, plus there was also, the state says that she consented, and I'm concerned with the consent part. So in order for the consent to be meaningful consent, what ought they have?
Well, let me answer your question in two ways, if I may. I can try. The one way is knowing there is a possible prosecution on the other side.
Yes.
Then there's certain issues that need to be told. Assume it was one of these cases where the person is being deported, but they're not facing charges in any other country. They're just an illegal foreigner, they happen to be here. The first scenario, the court can get guidance from that which is contained in a consent. Let me just give the interpretation. What happened here was Mr. Spagney was in the US and he consented to come back to South Africa by way of extradition. And the neutral citation is 2023 ZASCA 24/13 March 2023.
Sorry, give us a...
Sorry. The neutral citation is square bracket 2023
Yes.
ZASCA 24/13 March 2023. And there are two judgments. The one is by Majali AJA and the other is by Dambuza JA. But in paragraph... So what happened? Let me just explain what happened. So he came back to South Africa having waived his right to contest extradition in the US. He comes to South Africa, and because he waived, he was now in South Africa. And my junior and I, Mr. Peremontsami, appeared on his behalf in this court, arguing that the South African extradition request to the US was unlawful. And this court found that it may or may not have been, but it was moot because he'd come back to South Africa and he was in South Africa having waived his right to contest extradition and consented to extradition. In the judgment of Majali AJA, she explains what he did when he consented. And there's a long piece around paragraph 19. As regards the argument that the extradition request continues to have legal implications, it is essential for proper consideration of that argument to quote the contents of his affidavit filed in support of his waiver of rights pertaining to extradition. They are as follows, and he explains in detail as to what he understood to be doing when he waived. He said, I am the person, this is the request, I accept the request, I want to go back to South Africa to continue the trial that I'm now facing in South Africa, etc. And there's useful information on that aspect. But assume, for example, Justice Catherine Sidioni, that there is that this is just a free person, if I may put it that way. No pending charges, no bad taste about the person, they just happen to be illegal in the country. In this country, the law is that the person may be arrested, and I emphasize the word may, pending deportation, or pending, I don't like that word, pending departure. The departure and deportation may have different elements. Departure is voluntary by the person themselves. Deportation has an element of state coercion. And in this case, because the person was prohibited, it's hard to, for the reasons that I articulated, it's hard to think away the South African charges. But we would submit the following on a very simple level. One, the person would have been informed that they had been found to be a prohibited immigrant. They had been given the notice of the 12th of April 2023, which she wasn't. And it would have been explained to the person that you have the right to leave Tanzania at any time before the 15th. And what is interesting is when has regard to the notice itself, there is a stamp.
Well, in South Africa, you wouldn't have had that immediate notice to leave. I mean, you would have had rights of appeal and whatever else. You would have had a number of steps. But I suppose if you voluntarily decide to leave, then you could leave. But
well, we would submit similarly when has regard to the Tanzanian Immigration Act, which is attached to
the basic proposition, Mr. Katz, is for any waiver, you need to have full knowledge of the rights you're waiving. And it's as simple as that, isn't it? We don't need to go into all sorts of detail.
There wasn't a waiver in this
No.
case. No. That's the point.
But you're saying for purposes of, in order for her to have waived her rights to all the extradition rights, she should have been informed of what those rights were before she consented. I mean, isn't that your case?
That's the case.
Well, you don't go that far. You simply say there is no indication that she was aware of any rights.
Yeah, so she
And
was,
that's as far as one needs to go in terms of a waiver, is it not?
So I turn to Remy. May I turn? Yeah.
Was it ever established whether the appellant had legal assistance in Tanzania? Because I think somewhere the respondent is saying
I think at some point
she disclosed that
Yeah.
she had legal assistance.
She said so in her bail application.
Yeah, she said so. She said so. Let me put it this way. Whether she did or she didn't, it doesn't take that question of waiver or consent any further. But I find it hard to argue the requirements for full knowledge of the rights in a deportation context, bearing in mind the context of this case, with the crime hanging over the head in the
but basically you're saying that this was a disguised extradition. They used what? They basically used a mechanism that they shouldn't have, were not allowed, not permitted to use for purposes of being returned to the country to be prosecuted, basically.
And let me, and one of the aspects is which I would ask the court in its consideration to take into account is that this isn't one of those cases where there's no extradition agreement between South Africa and let's call it the other state. Because that can make a difference. Because here, the states had not only a right but an obligation to use certain mechanisms which are set out in a protocol. And they didn't. They went around the protocol. That's the point that is made in Alvarez and Shane. And that we don't think is unimportant for purposes of this case. So I do want to turn to...
Sorry, before you go further, Mr. Cos, there's something that sort of worries me, and is the following. Now, the allegation by the respondents is that she consented to her deportation, and to what extent does her bail affidavit support that contention by the respondent? Because I'll tell you what she said and what she didn't say in her bail application.
We say two things.
Sorry. Well, what she said,
Just on...
okay. All right. The allegation is that she said, I wanted to go back to South Africa to my children. And lo and behold, at that bail hearing, she said, I've got two minor children, age 11 and 6, respectively. Paragraph 7.3. Setting out their family background.
Yes, I have that.
Okay. And then you said, I've got two minor children, 11 and 6. And then she further says, I have specific parental responsibility
Yes.
and rights with regard to primary care. That's what she says. She goes on to say, paragraph paragraph 8 now, circumstances around my departure from South Africa.
Yeah.
She says she was instructed and commanded by accused number 5 that is best to get into a vehicle and leave the premises to a destination unknown to her. When she refused, he forced her into the vehicle. She succumbed to the threats. She was defenseless, and she complied. That's what she says. She says, in any event, I had no reason to leave South Africa. That's what she says.
Yes, that's good.
Now, isn't that supported, at least the contention by the respondent, that she said, I want to go back to South Africa to join my children, to be with my children, because of the circumstances in which she left South Africa. According to her, she was forced He didn't want to go to Tanzania. His pastor who forced her and put her into the car. She left her 2 kids here. She wanted now to go back to her kids in South Africa.
I want to make 3 submissions.
Yes.
The first is, what is contained in the bail affidavit is a matter of principle irrelevant to this question of consent. And I'd pick up on Justice Corbyn's comment or understanding, and Justice Cathry, that waiver needs to be proved, and there's no suggestion that on the 12th of April she knew what her rights were. Whatever her mindset might have been, it's not proved that she wanted to come back to South Africa in the circumstances in which she came back. And let me just stop for a second while I'm on this point. And Justice Cathry Sipioni's point is I'm going to come to, it's not a very good question, which I didn't answer in a way that I might have. Under the SABC Protocol Extradition Treaty, there are various rights. One of them is the right of speciality. And that right gives the person targeted in extradition the immunity, if that's the word, for prosecution for other than that for which they have been extradited. So if she says to the bail court, and that's what she says to the bail court, didn't want to leave South Africa, I want to be with my children, that doesn't mean that she should have been, let's call it, disguised extradition back to South Africa for anything to happen. And we know in the warrant of arrest, the Section 43 warrant, it's only fraud, but now that she's back, there are all these other charges. That's the first aspect of it. So even if she didn't want to leave South Africa, but was forced by Bester to leave, is not a reason to find that when she was confronted on the 12th of April, sometime later, that constituted a waiver because she wanted to be back with her children in South Africa. Number one. Number two, when she filed this bail affidavit, the day she filed it, and the court will see, the 29th of August 2023, she signed it in August 2023. On that date, there can be no suggestion that this case, the case that we're now currently dealing with, was in any way abandoned or dealt with anyone. I think at that point the petition was pending. And to suggest that not only did she waive her right to come back to South Africa, but she also waived or preempted her right in this case, we would suggest has no merit. So that's the import of the argument. That must be the consequence of the import of the argument that says, well, this affidavit endorses that which is contained in the 2 paragraphs in the police's replying, answering that.
Mr. Katz, on a factual level, if she was taken to a place where Home Affairs, police, whatever, and she said, I want to go home to South Africa, and they took her home, does that amount to a disguised extradition?
Yes.
Why?
Well, no, sorry, on the facts, yes.
On the facts.
She didn't know her rights.
No, forget about waivers. I'm not talking about waiver now. I'm talking about the fact that she's brought into what was it, the South African...
no, it was the airport.
Okay, she was at the airport, and she says, I want to go home.
No, I'm not sure she says that.
Well, I want to be with my children, she said.
That's what she says.
Yeah.
She says the following.
At Kilimanjaro Airport.
She says, this is what he said. It's on page 63, 64.
64, the applicant informed all and sundry that she wanted to return to South Africa to her children.
Yes.
So I want to go back to South Africa to my children. Does that then form the basis for a disguised extradition?
Yes.
If she volunteers that, is she still now actually, you say, that's amounting to some kind of waiver?
No, I'm saying it's not a waiver.
No, I'm saying that you have to prove a waiver.
Yes, that's
still, in those circumstances, where she comes to these people and she says, I want to go back to South Africa to my children.
Yes.
Is anything wrong with that? If she then gets taken back?
Well, all I can do,
that's the case of the respondents, Mr. Katz.
Yes.
That's the case of the respondents. I want to go back to South Africa to be with my children, or to my children. And
I'm now just So I have two responses. Firstly, as a matter of principle, that's not good enough.
Sorry,
It's not good enough to dispel the notion that this was a disguised extradition as a matter of principle.
why is that?
Well, in the circumstances, she's at the airport and she says, this is assumed she says it. I'm assuming
She's serving an economy passenger flight, Mr.
Excuse me?
Okay. She's serving an economy passenger flight.
And
No, I'm
you
being
can-
facetious, but
you
I mean,
are paying for it.
am I asking?
You and I are paying for her economy flight.
No, that really was facetious. But is there anything wrong with her in those circumstances saying, I want to go back? And basically in her mind, I've been abducted by this bloke here. I want to get back to my children. She says in her bail thing, I was also practicing at my clinic until such time as I was,
Yes.
Yeah. Now, she's unlawfully abducted,
By
by her
Besta.
version, by Besta, yeah. She gets to Tanzania. She's suddenly arrested by the Tanzanian people because she's actually unlawfully there. South African people pitch. Let's just put it at that level. And she says, I want to go home to my children. What is that? Is that an extradition? Is that a disguised extradition?
Well, let's put it this way. Perhaps I should spend some time on the point. There's a judgment of Justice Pruneman called Vellum, which we've included in full in our bundle. I have to, at the outset, say that in a case called December, this court found that Vellum was wrongly decided.
Yeah.
But the proposition that Justice Pruneman articulated,
That was the Transkei, or Ciskei rather, something like that. Yeah.
I'm just looking for where it is. It's on page 26 and following. I just want to make the simple proposition that where the, let's call it the extradition stroke deportation is achieved by way of craft or cunning, those are the words that Justice Pruneman uses, that in and of itself amounts to unlawfulness.
Is that shown on the papers here?
Yes.
Craft or cunning?
Yes.
On whose part?
On the South Africans' part. They
Why?
turned up, as Justice Ward, when you put it, they pitched. What were they doing there?
They were there to get Besta back. Let's just leave it at that.
Well, have you seen what, then you have to look at what she says in the replying affidavit. The court cannot ignore what she says in the replying affidavit. So when I argue this case, I'll argue it on her version, included in what's in the replying affidavit, without an answer. So we can't suck out bits and pieces of what the police say and Home Affairs don't say. There's no explanation of who she said it to, all and sundry, by policemen. What does that mean? And what did they tell her before she said, I want to go home? Maybe they said to her, well, you're going back to South Africa, and maybe she said, oh, well, if that's the case, I'm looking forward to I want to go home to see my children. We don't know.
Well, they were brought to court on the basis of an unlawful arrest by the South African police on the 6th of... Yeah, that's the case that they were brought to meet, and they go into all the sound detail that they didn't need to go into. Saying, I want to go back.
No, Zealand says the exact opposite to that which Justice Gorban, you're suggesting. It said she did enough. And Jibite
Once she's proved of her deprivation of liberty, yes.
She was deprived of liberty.
Well,
and she says, I can't do better than
I think
she
we've
said.
gone through that, Mr. Katz. I think the point is, I mean, this is not a case which falls within the Ibrahim type of situation. Would you agree?
No.
Because in Ibrahim, it was clear agents of the apartheid South African government abducted Ibrahim and brought him to South Africa, and he was arrested in Pretoria ultimately.
I can't disagree with that. Those are the facts there.
Yeah. So it takes out, the facts take it out of that realm of abduction, apprehension in a foreign country. Isn't it?
I'm not going to. I'm not going to deviate from our position.
Yes.
That what happened to the appellant on the 12th of April 2023, in respect of the conduct of the South African authorities, was unlawful, unconstitutional.
Right.
That's the argument.
I think that we have made the
I think
point
we
there.
understand that.
Thank you.
And I've made the point that I cannot make it any further that the we must be careful as a society not to. Well, she did a terrible thing, and then, as the Constitutional Court says, use questionable means on that war and crime. No matter how we put it, it not be as the Alvarez Machine type or the Ibrahim type, but it's a principle. They wanted her to stand trial. There was an arrest warrant waiting for her. And what did they do? They agreed, they colluded with a foreign state to achieve that. That's the bottom line. And when one talks about an apartheid state, of course, I won't say it's different, because here and I made the point in my introductory paragraph, the executives of the world must be careful, and the courts are there to ensure that this type of conduct doesn't take place. I do want to come to 3 points, and I've exhausted my time. The first point is, attached to our heads of argument, there's the judgment, the speeches of the House of Lords, and in particular the majority speech of Lord Griffiths.
Sorry, your heads of argument, you say?
Attached to our heads of argument. It's in, I'm just hoping it's correct. It's in our small bundle of today. We gave it to, it's in a small bundle of today, so you don't actually, no.
In the original bundle of authority.
No, sorry, it's a bundle of authority attached to our heads. That's right. Original heads.
Yeah.
And we ask, and Horsbury, the facts are always interesting. He was in Cape Town, and he was wanted in New Zealand. So he found himself on a plane, being open quote deported to New Zealand. And we know that South Africa doesn't have direct flights with New Zealand. So the flight went from Cape Town to the UK. He got off in the UK, and the next thing he was facing trial. No abduction like Ibrahim, no abduction in the sense of Alvarez Machine. In undumbered paragraph on page 39, page 61, next to letter H, Lord Griffiths, for the majority, says, "Your Lordships are now invited to extend the concept of abusive process a stage further. In the present case, there is no suggestion the appellant could not have a fair trial, nor could it be suggested that it would have been unfair to try him if he'd been tried or returned to this country through extradition procedures. If the court has the power to interfere with the prosecution in the present circumstances, it must be because the judiciary, and we would submit that the 5 wise justices accept a responsibility for the maintenance of the rule of law that embraces a willingness to oversee executive action and to refuse to countenance behavior that threatens either basic human rights or the rule of law. My lords, I have no doubt that the judiciary accept this responsibility in the field of criminal law. The great growth of administrative law during the latter half of the century has occurred because of the recognition by the judiciary and parliament alike that the function of the High Court to ensure that executive action is exercised responsibly and as Parliament intended, so also should it be in the field of criminal law. And if it comes to the attention of a court that there has been a serious abuse of power, it should, in my view, express its disapproval by refusing to act upon it. Let us consider the position in the context of extradition. Extradition procedures are designed not only to ensure that criminals are returned from one country to another, but also to protect the rights of those who are accused of crimes by the requesting country. Thus, sufficient evidence has to be produced to show a prima facie case for the crime. This is the important point. If a practice developed in which the police or prosecuting authorities of this country, and you can include Home Affairs, ignored extradition procedures and secured the return of a person by a mere request to police colleagues in another, they would be flouting the extradition procedures and depriving the accused of the safeguards built into the extradition process for his benefit. It's, to my mind, unthinkable that in such circumstances the court should declare itself to be powerless and stand idly by. I echo the words of Lord Devlin: the courts cannot contemplate for a moment the transfers to the executive of the responsibility for seeing that the process of law is not abused. And we submit that on all grounds the process of law was abused. Now I do want to turn to that, and I just want to, in our heads of argument, we make the point that Vellum was, which is the craft and cunning point, was overturned or rejected by this court. Now, I want to make 2 points. One is those cases are distinguishable. We make that point in our heads of argument, and we say they're distinguishable because in December and Mahala, unlike in this case, and in this case the High Court found that there was unlawfulness. In those cases, the court found that there was no unlawfulness in the obtaining of the person in Ciskei and Transkei, whatever the events were. The second point that I wish to make is this. We've attached and we've referenced various articles, academic articles with reference to international law by Professor John Dugard and others, which said those cases were aberrations. Firstly, that the events there happened prior to the Constitution. But if this court rejects the appellant's appeal for any reason, we would say this court is going back to pre-Abraham days. And that's not something that we would suggest is something that the Constitution would be inclined to endorse. The last point that I wish to make, so we would say that Vellum is the standard bearer for the type of argument that I make about Croft and Curran being the extension of Justice Makgotlo's Ibrahim point. The last point that I want to make, which is the last chapter, and this is not in our heads of argument, it's a new point, and it's a response to an argument which at first blush might be attractive, but we say it's got no merit. And that is this. The police say the following. If you are with us that this was a disguised extradition and it was unlawful, nevertheless, under section 172(1)(b) of the Constitution, this court should exercise its remedial power to grant a just and equitable remedy and give, open quote, the trial court's jurisdiction. And there seems to be something attractive on the point from a public opinion point of view. Well, the government acted badly, this was a disguised extradition, but the appellant should not get off. Which is the rule. The rule is a disguised extradition, the trial court will not exercise jurisdiction. So they say there should be this just and equitable remedy.
Well, they're saying you must balance all considerations.
Excuse me?
They're basically saying in granting just and equitable relief, you need to balance all the considerations. Yes. So you've got to take into account the victims of the crimes and their families.
That's what they say.
So, and what is your point on that? Yeah.
Justice Untalte in the Constitutional Court explained the problem. The problem is that's reverse engineering, he called it. Because this isn't about balancing of rights in this sense. This is about jurisdiction. And jurisdiction is a binary concept. Either the trial court has jurisdiction or it doesn't. And if it doesn't have jurisdiction, 172(1)(b) can't give it jurisdiction. And in this case, we're slightly different on that point, but the principle is there. And it's page 50 of our bundle. He says, for these reasons, I conclude the application before us must fail. The Constitution does not give this court the power to make the declaratory order sought, so as then to entertain an application for leave to appeal from that order. It's about an equality court order which wasn't followed up. Nor is this court competent to enforce the applicant's rights of access to the equality court when the applicants have not moved the equality court. I appreciate that the applicants have with much persistence requested the presiding judge in the equality court to convene. His failure to do so is to be deprecated. What is required is an application brought urgently to that court. Now, if we turn up in the paragraph, so that's the background to what actually happened. So what the equality court wasn't listening to the social justice coalition. They tried. And eventually they gave up trying and they went straight to the Constitutional Court. And in paragraph 149, he deals with this, we would submit, firmly with the kinds of argument that the police have produced. It follows that this court is not the competent court. If I find, and this is next to the letter, between the letter A and B, as I find this court therefore lacks jurisdiction to entertain it, there can be no basis to source its jurisdiction by recourse to a determination that the applicant's rights have been infringed in the wide remit of section 172 that gives the court the power to make an order to cure that infringement. Jurisdiction is a binary concept. A court either enjoys it or it does not. This court cannot simultaneously lack jurisdiction in terms of section 38, but enjoy jurisdiction in the 172 point. Section 172 makes this clear. When deciding a constitutional matter within its power, is the introductory words to 172, this court must enjoy jurisdiction to decide a matter. If it does, only then may it exercise the remedial powers. The first judgment holds in the proposition that if a minority is required to make good an infringement, this court enjoys jurisdiction. And an important sentence, that reverse engineering of jurisdiction is not, in my respectful view, a tenable interpretation of the Constitution. And that was for the majority.
So, what is the citation of the case? Because you said it is not covered in your case.
Excuse me, the citation is on the left-hand side.
Covered in your case.
It's Social Justice Coalition and Others versus Minister of Police and Others. It's reported in 2022, Volume 10, BCLR, Butterworth's Constitutional Law Reports 1, 2.
Sorry, you're going so quickly, Mr. Scott.
Excuse me?
Just slow down, please.
No, it's on page 49.
Oh, it's on your page. Is it here? Okay. Thank you.
Okay. So the point is,
Okay, it's 49.
the simple proposition is, a learned friend's argument about 172 being, in this court being invited to exercise 172 powers, would be what we would submit would be reverse engineering, and not contemplated by the Constitution as a piece of it.
Thank you. Okay.
Thank you.
Thank you, Mr. Carter.
Thank you for allowing me.
Yes, Mr. Stillenberg.
Thank you, Justice.
Yeah, you had a debate between the court and Mr. Carter.
We followed the debate,
But yeah.
thank you, Justices. We started the by stating the obvious, which one should never do in starting a conversation. Each case on its own facts. In this matter, the applicant is not and was not a layperson coming to court saying, somewhere during the night I was taken, I don't know why I was taken, I don't know by whom I was taken, and I was detained and I was deprived of my liberty. The applicant had a very fact-based case, set out in detail in paragraph 8 of her founding papers, stating that on 6 April she was abducted by the South African Police Services. She didn't say she was not sure who to go. She never said so. In fact, if justices have regard, this becomes important with regards to the pleading argument. To the DHA, that was the 6 respondents, answering affidavit, they appended to that affidavit at page 160 a letter that was drafted by the appellant's attorney, the representative. This is the 23rd of May 2023, after the founding papers were filed. Court will bear in mind that it was done on an urgent basis. The respondents were under severe truncated periods to respond, and yet DHH address, they respond to letters apparently addressed to them by DHH, wherein DHH explained, if one looks at the reply, what according to them transpired. And the upshot of this letter is that the appellant says 2 things. 1, your version is not true. My version is contained in my founding papers. 2, I'm not going to join you. So if you want to join the proceedings, feel free. But I don't have any issue with you. Whilst in this letter they list why on that explanation they think it would have been an disguised extradition. What the applicant did not do.
Well, what did she ask in the letter? Who was involved from the DHA?
She asked nothing in the application.
No. So this letter you're talking about, the 23rd of May letter. Yes. What was the significance of that letter?
They asked her to withdraw the matter.
Sorry.
They asked her to withdraw the application against them, and she said she's refusing to do so.
Oh.
And if
Was
they
that the
want
letter
to,
from the state there?
No.
I thought she wrote it.
He's still under immunity, you remember. 10 minutes.
Oh, I beg your pardon, sorry.
That's not a problem. But that letter was addressed by the appellant's attorneys to the to DHA
Even I was holding back.
And she quite pertinently says that she refutes what they say. That's not her case. Her case is quite clear in the founding papers. And if they want to place that before court of anybody else, they must do so. She does not file a supplementary affidavit. She does not amend the relief she seeks in any manner. She does not bring an application to expand, which we suggest is what she should have done, the basis for the relief and founding. She just leaves it. The relief, as Ms. Gorman pointed out in the notice of motion at page 1, was never altered, was never amended. There was never an application to do so. So when one looks at page 290, that is the notice of appeal, one is quite surprised that without any application to this court, there is an attempt to say that this court must now grant different prayers that was sought in the court of quo and what the respondents were asked to respond to. Not only is a sixth respondent introduced into the prayer, but there are also now declarations with regards to acts being inconsistent with the Constitution. And we also know that the prayers was also contained in the heads of argument. What the respondents contended from the start is, and nothing that we'll just show the court that it's not correct that this has been disturbed by any court. Before there's any reverse onus in matters like this, the appellant must show that her liberty was deprived and that she must say who did so. And we've referred the court to the Machlangu and another of this Minister of Police judgment, for one, which says that the plaintiff has to establish that an interference has occurred. Now, how do you do that? The appellant told us how she said it was done and by who. Once that has been established, there's a factual dispute here, then there's a justifying onus resting on the respondents. Now, the mainstay of the argument became that because the South African police services were present in Tanzania, if I understand it correctly, when a handover took place, therefore by part of the arrest. But that does not track with the evidence. For example, paragraph 69 at page 60. This is the answering affidavit. SAPS members travelled to Tanzania on the DHA plane, did so for purposes of providing escort to the DHH officials. After all, the applicant was in the company of Bester, a man who had been convicted of murder and rape. These SAPS members did not travel to Tanzania to arrest the applicant. Cannot be stated in more unequivocal terms. Page 64. At paragraph 78.10, the appellant was never arrested, as stated, nor was she handcuffed at any point before or during a flight from Tanzania to the Republic of South Africa by the SAPS. She's being utterly untruthful, with allegations that she was blindfolded and abducted. Nobody flanked the applicant in the sense that she conveys. There are only the limited number of seats on the plane. They also go further to state that there was also no defense. Then we get the 6 respondents. Affidavit, page 142, paragraph 26.
Sorry, page?
Page 142, paragraph 26. Members of a special task force and the official of the correctional services were mere spectators during the handover process. Can't be more clear. The applicant was at no stage blindfolded as alleged when she was handed over by Tanzanian immigration officers to the High Commission. Page 146, paragraph 40.2 of that affidavit. The applicant was not arrested by members of SAPS in Tanzania. She was arrested by Tanzanian police. As indicated above, her arrest by a member of the SAPS was effected upon arrival at the Lanseria Airport in South Africa. Return the page to 147, 41.2. The second applicant was handed over to me, the deponent to this affidavit, Mr. Matthews. And the handover notice was signed by me. This much is clear from Annex DH A7C. Third, no member of SAPS in full uniform arrested the applicant in the manner alleged by the applicant. I, in any event, would not have allowed such conduct from any person. The Tanzanian immigration officers have made it clear that the applicant investor would not be handed over to members of the SAPS and or transportation belonging to the South African Police Services. So, not only has the appellant not established her case, which she set out in paragraph 8, we also know from the uncontested evidence, the evidence that we must accept, from both DHH and the first to third respondents, that the South African Police Service in the first place never went to Tanzania to arrest the applicant. They were there, they were observers. They never did anything akin to restraining her, abducting her, first forcing her onto the plane. And there is nothing in the papers on which the appellant can rely that refutes this. Now, she says that, well, these are sui generis proceedings. Once she has complained that her liberty has been limited or taken away from her, there's a general onus on the respondents. But in this matter, she took the first to third respondents to court. And that is the case that the respondents had to answer. And that is where Tseletsani comes in. Because the fact that they go further, but they didn't go further in the sense that they were in any way implicated in any unlawful or underhanded conduct. There's no merits in any argument to say that they coerced or used stealth to lure the applicant to get on that plane. Nothing. There's no conduct whatsoever on the part of the SAPS. If we accept the respondents' versions, that brings them within the Ibrahim sphere. Not even in the other matters. Just as if we look at the applicant's affidavit, she came to court with a set of facts, which she then totally abandoned. In this appeal, she doesn't touch on the case that she made in finding. She relies solely on what she said in reply. And the accusation now is, but you should have come and asked leave to file a further affidavit to respond thereto. Why would I file an affidavit or ask leave to deny something that she denies, which I've already positively asserted on oath, knowing what the rules of the game are, so to say? Why would anybody do that? It doesn't work that way. That's the first issue. The second issue is, now we know that the appellant says she was taken against her will from South Africa. She didn't want to leave South Africa. She's a doctor, she's got a practice, she's got 2 kids. She is the primary caregiver. They reside with her. She had nobody to complain with. She finds herself in a foreign country, in Tanzania. Here comes the South African deputation. There's a plane. And she says, I want to go home. What should they have asked her? Should they have said, no, we're leaving you here? Why should they have informed her of anything? She says, I want to return, and now we know why she wanted to return. She wanted to come back to her children. That's always been the first to third respondent's case. It's never been anything different. And what is wrong with it? What is unlawful about that? Nothing. And none of the submissions that have been made detracts from that case. It's not, it hasn't been in any manner on the merits been challenged. It can't be challenged. It's just simply denied. But we know why she did what she did. So she wasn't arrested and forced onto the plane. She hitched the ride, to borrow a term, but that's exactly what happened. Why was the police there? We know that as well. Everybody knows that. Because there's a convicted rapist and murderer, and it's going to be exported back in a South African plane with South African officials. So that precaution is quite reasonable to take with respect. And that is as simple as this case is, on the law and on the facts.
Okay, I just want to warn you at this stage that your 10 minutes of immunity is now up.
More
You may
welcome.
start expecting questions from
Yeah.
the members of the board.
Mr. Sandberg, in the answering affidavit, there's reference to Section 41 and that the DHA and the police
depart-
acted in terms of
yes.
Section 41. What do we make of that?
Justice, I can't really, I can't speak on their behalf. I think one has to see these facts in the proper context. I think Justice Gorman said they were probably mistaken, but
They were
that's not,
But it doesn't.
it's neither here nor there as far
Yeah,
as the appellant
okay.
is concerned.
It's just a neutral fact that we
It's
don't
just
need to.
it's just a nice thing for an unsuccessful litigant to raise when you want to, appeal, but it doesn't take this matter anywhere.
Sorry, and on your case, the deportation by the Tanzanian, well, it was the deportation was carried, the arrest was carried out by the Tanzanian government.
Just
not the South
aside
African.
for inferences, for arguments that are raised, that whole issue with regards to disguised extradition.
No, sorry, I'm just, I'm still asking the question. So basically you were saying there was nothing wrong with the deportation by the Tanzanian government. I mean, that is not what's in question here.
They decided to deport.
So basically the deportation was lawful.
Yeah, they took a decision to deport her. She said, I want to come home. She got onto a South African airplane.
Yeah.
She came
So,
back
so,
to her
so,
kids.
so having consented to coming home, then was there any duty to basically inform her of what her rights are
Why?
in relation to the fact that she may be prosecuted
The
in South
answer to
Africa?
that is simple. If she says, I want to go home, why would I say, wait, before you do so?
Yes, but in the Mohammed case, remember,
But
Mr. Mohammed said
was-
he wanted to go. He volunteered to go.
Yes, but
Right?
there
And faced-
the Concord,
But then there was the issue of the death sentence
Yes,
and whether
that
he
was,
could actually give consent in those
that was
circumstances.
a big issue because
Yes.
what the Concord quite expressly stated is they doubt that anybody would ever be able to consent to capital to be delivered to a state where there's capital punishment. Remember, Justice, also the other distinguishing trademark of Mohammed is that he came to our country illegally and we sent him to not to his home country but to another country, to the United States, who had the capital punishment for the crimes that he committed. But Mohammed, the Constitutional Court, had no problem with consent whatsoever. It was the facts of that matter that raised the eyebrows.
Yeah, but it was the pivotal concern was that
Yes.
he'll face the death penalty. And how can you possibly consent
Yes,
when
which
that
is
is
a
something
valid
that is
point.
facing you? Huh?
Which is a valid point.
Mr. Stellenberg, the analogy was given in one of the cases relied upon by Mr. Katz of the re vindicatio. But in a re vindicatio, you need to prove two things: ownership and that the person from whom you're claiming it is in possession.
That's what
So the analogy here would be surely you've got to prove I was deprived of liberty. And then the owner shifts to say, well, I've got better title under the re vindicatio to you to hold this as possessor.
the Concord
But surely
actually
you've at least got to say, I was deprived of my liberty. Ibrahim, it was obvious, it was deprived. All of those cases.
Smith versus Rubenstein, Pleadings and evidence.
All of those cases. So there's no immediate onus,
No.
simply because of an assertion.
Yes.
You need to be deprived of your liberty by the person concerned. I mean, it's a complete defence to the re vindicatio to say, I'm not in possession, my brother Mahoka is in possession. That's a complete defence. I'm not in
That's
possession.
correct, Justice. And that's also
This is a similar analogy, is it not?
But that's
The
reason
police are saying, we didn't do anything. We did not arrest.
Yes, exactly.
And there's not a jot or a tittle of words about the Home Affairs in the founding papers, is there? No.
And Justice, that analogy that we just raised, the Constitutional Court actually adopted in the case we'll refer to. They adopted that, and the case well, and a colleague referred to, in the sentence before, the sentence very long, refer on all the old well-established right cases with regards to deprivation of liberty, which states exactly this. So to just take that sentence as meaning something more, we respectfully would join issue with.
Mr. Stellenberg, that letter of the 23rd of May that you referred us to, I mean, her response there was quite clear what the case is, that she was arrested and abducted by the SAPS, am I right?
Yes.
So it was a reiteration of
Yes.
her case once again.
Yes, Justice. Her response was, "You lying. I don't accept what you say. It's not true. My version is in my papers. Do what you want to, so to say." So she's in a totally different position than any other plaintiff in these circumstances in any event. But the one thing she cannot come to court to say is, because we get cases like that, where a person says, somebody came to me, he forcefully forced me into a vehicle, and later he sits in prison and he knows, well, I was apparently arrested. I don't know for what, was a plainclothes officer. Those circumstances, by all means, the rules of the game is different. But in this matter, it's not. This is just a point we want to make. If the amendment that our learned colleagues now sought, if the court is not with him on certain points, that would mean that relief is taken away from the only parties against which it was sought in the court of quo, and it will now be granted against the party against it was never sought in the court of quo. You don't understand the laws of litigation to quite countenance that, because
and who you specifically, pertinently decided not to join.
Express election.
Yeah.
Express election. Yes, I was just, I think I did make this clear, but that letter from in reaction to DHA that I refer you to was 3 days before the first to third respondents filed the answering papers. So
3 days before.
3 days before that already. She knew exactly what DHA would say.
It was 3 days before the respondent filed its answering papers.
Before the first to third respondents filed their answering affidavit, and after only, Justice, you will recall, everything happened in a very rushed manner. There was a joinder by DHA, and they then filed their affidavit thereafter. So she made an election not to expand the case, not to seek alternative relief against them, not to amend the prayers. That also features prominently in the application for leave to appeal in the judgment, where the constitutional attack comes in. But yet again, there was never any attempt to amend, to even amend the prayers.
And on the Ray Vindicatio analogy, if the person who I point to as being in possession decides to join in the action and says, well, this is what I did, and it actually fact amounts to them having possession, unless you amend the relief, you still can't get relief against them.
Yes, that's exactly so. So just maybe make a comment with regards to this. We submitted that this matter shouldn't get here, but just with regards to the case that I learned colleague, we got notice of it this morning. I'm not objecting there to. But the case Judge Interalter was dealing with was dealt with statutory jurisdiction. Here we're dealing with a matter where a court, by declaring certain conduct unlawful, says, well, this court will not have, the criminal court will not have jurisdiction over you. It's something different. And we know what Section 172 says. When conduct is declared unlawful, the court has the powers in terms of 1B.
It's a wide discretion to be exercised judicially. I'm really not sure that this argument helps you too much, Mr. Snellenberg, but perhaps one doesn't have to get that far.
Yes, but there's something Judge Tuan pointed out. There are a lot of interests that are in play.
Well, and part
the
of
court
that,
either has jurisdiction or not. You can't.
But
You can't say this is not statutory jurisdiction, so it doesn't matter.
This point with regards to jurisdiction in Abraham was said, well, because the state hasn't brought you before court with clean hands. But we also know there's a lot of case law that says that an unlawful arrest doesn't mean that the prosecution is unlawful or void. So it's not as clear cut, to be respectfully said, but we understand totally what the rationale for the room was. We don't join issue with it at all.
So basically, you're saying the criminal proceeding should continue. That shouldn't be rendered a nullity.
The prosecution should be able to continue.
But she should be released, and the prosecution should continue.
If we get to that.
But I've got to say that Ibrahim is the gold standard for me still. You know, I mean, if that's the situation, the rule of law demands release on the basis of no jurisdiction. So for me, it would run counter to that notion to invoke some sort of discretionary relief which actually abrogated the rule of law. That's the point I'm making now in relation to your...
I must confess, we were not totally prepared for this argument.
No.
This is what we've been able to say, but we do respectfully submit there is clear distinguishing factors between the judgment of Justice Interroll.
It's akin to the powers that the court has in terms of Section 173. Those powers would not allow a court to exercise jurisdiction where it does not have.
No, our submission is clearly that we look at how the incompetence arises as a result of a finding of unlawful conduct. Obviously against the facts of the matter, but I'm not going to labour that point. I'm not that well prepared to do so. I just want to, we can at least make a submission that there is a distinction between the matters.
Pointed. Any further submissions? Thank you, Mr. Nandipha. Anything in reply, Mr. Katz?
Just 2 points. Thank you, Justice Sonja. Just 2 points. The one point is the question of amending relief. And this court and the Constitutional Court have over and over said that in a case such as this, the court, and for that matter the respondents in a case such as this, are not bound by the form of relief contained in the notice of motion. And what the court will do is consider the pleadings as a whole and give the appropriate constitutional relief that sorts from the papers.
So in the Ray of Vindicatio example, B, who comes to court of his own or her volition, and it becomes clear that they've got possession, without any amending of the relief, you can actually get an order against them, you say?
Yeah. Well, against the other party.
Yes.
Of course, in a constitutional matter of this kind. That's what Zealand says. It says it in terms, effectively, in paragraph 26 on page 37. How can it be otherwise? They're not here. And in any event, the main relief, the main relief did not exclude them from the attack. So on page 1, it doesn't talk about the police.
No, but the case made out is the police only. There's not even a mention of NHA, of Home Affairs.
No, sorry, with respect to the Ray Vindicatio scenario. I come against you for a Ray Vindicatio. It's my property, you've got the property, ask the court to order it back. And your defense is your brother next to you has got it. And your brother next to you is a party to the proceedings and files an affidavit explaining whether he has it or not. Of course the court has got jurisdiction to grant an order against your brother.
Without an amendment.
Excuse me?
Without an amendment.
That's what Motorclip says. It's exactly what Motorclip says. Twice. It's in this court by Harams J in paragraph 18. It's paragraph, read from Motorfontein. This is this court. Paragraph 18.
Of which judgment?
Excuse me?
Which judgment?
It's in our heads of arguments called Motorfontein Squatters versus Motorclip, Boerdery 2004, volume 6, SA 40, and in particular paragraph 18. And by the way, the Constitutional Court affirmed this in the appeal to the Constitutional Court, judgment of Langer CJ. In paragraph 18, I'll just read from, well, let me read the whole paragraph. In light of the foregoing, it is not surprising that at the hearing before De Villiers J, Motorclip and Agri SA accepted the unconditional removal of occupiers was not a viable option. Instead, they proposed an order in 2 parts. The first, a declaratory order relating to the state's constitutional obligations toward not only Motorclip but also the occupiers and the second part was a mandamus requiring the state to submit to court a comprehensive plan. In the court below, the state objected to the new direction, wishing to hold Waterklip to the relief originally sought. It's an echo of what we've heard here. The objection was overruled by de Villiers J, correctly so. If a constitutional breach is established, this court is, as was the court below, mandated to grant appropriate relief. A claimant in such circumstances should not necessarily be bound to the formulation of the relief originally sought or the manner in which it was presented or argued. That much is apparent from the course the litigation took in Carmichael and Ballantyne, and why the further amici, the Nkuzi Development Association, the Community Law Centre, the Programme for Land, etc., were admitted to the proceeding. So the simple proposition is what this court has as a factual matrix is, I'm going to leave aside the police for the moment, but as a factual matrix, we have the DHA relying on an incorrect section, an incorrect understanding of the status of the High Commission, and without giving an explanation of what powers they were exercising when the handover took place. How can it be said that, bearing that in mind, the appellant fails because they haven't properly identified the issues, when in paragraph 1 of the notice of motion they don't mention the police or Home Affairs, they say the state?
Sorry, when you say an incorrect understanding of the High Commission, can you just elaborate on that?
Well,
you just use the term.
Yes,
they had an incorrect understanding.
Very clearly. Santos versus Santos is a case in which it is said there was a debate about the status of the territory of a foreign embassy or high commission. And the courts all over the world, including the Vienna Convention on the Law of Diplomatic and diplomatic communities, etc., say that a foreign embassy is not the territory of the sending state. It's the territory of the home state. Now, unfortunately, the third secretary makes the mistake on page 179, and this is it's all parcel and parcel of the same thing. I'm sure I'm arguing. On page 179, paragraph 9, this is what she says. In simple terms, the premises of the High Commission are regarded as the South African soil and property that of the government of the Republic of South Africa. And then she attaches a copy of the Vienna Convention. And then she goes on in the affidavit to say, in paragraph 10, there was a meeting on 9th of April at the premises of the High Commission. And then and her reasoning is, because this thing took place, this meeting and the various aspects took place on the High Commission's territory, it actually took place in South Africa. That's wrong as a matter of international law.
Well, but in any event, whatever took place at the Kilimanjaro airport, which is not within the High Commissioner's premises. Is that not so?
That is so. What took place at Kilimanjaro airport stems from what happened in Tanzania with meetings of the South African officials. It all comes down to this collusion, this agreement.
Handover and whatever she says regarding the activities that took place. The handover did not occur at her place, at her workplace. It happened at Kilimanjaro airport.
I think she handed over to the DHA to
the
High Commission. She handed over to the DHA at the High Commission. Am I right? Did she not hand her over to the DHA at the High Commission?
No, not the High Commission.
Only at the airport.
At the airport,
okay.
yes.
So what happened? The meeting took place at the High Commission.
And the point that I make is this: the handover took place on Tanzanian soil to South African officials. We say that's unlawful for the reasons I articulate. I'm not going to repeat them. Section 41 has no basis, and there's no other basis. There's no basis in law for DHA to have been there, from a South African legal perspective. The only basis that they point to is Section 41, which we all know was incorrect. The question then becomes, what was actually going on in the surrounding circumstances? And one of them is that which is suggested to be contained in paragraphs 9, 10, and 13 of the answering affidavit of DHA. So in paragraph 9 and 10, I've already told the court that she regarded the High Commission as premises of South Africa. In 13, this is what she says. It's astounding to me. And I accept unconditionally that the police can't answer this. They cannot, because it's not their case. But this is what he said. The agreement, and I emphasize agreement, not our words, but her words, between the Tanzanian authorities and the High Commission to deport. So it's an agreement to deport. That's unlawful on every international authority that there can be. An agreement to deport between two state entities back to South Africa, and this is the important words, was reached at the premises of the High Commission. I'm advised that once that happened, the appellant and Bester, as a matter of international law, were regarded to have been in the custody of the High Commission on South African soil. With the greatest of respect, if this court can allow that kind of thinking to permeate a case such as this, where the liberty of somebody has been taken away in the dramatic circumstances, and I cannot emphasize how important it is that this kind of thinking be dealt with in some type of order that the court makes, a la Morofonte. It cannot be that these kinds of ideas permeate, and this is again questionable methods to wage a war against crime. The last point that's the one point that I wanted to make.
Yes.
The second point that I wanted to make was this, and I admit, and I have to accept, and I admit that I have some difficulties in making this point, but I do wish that the court has regard to what I'm now going to say in the context of which I'm going to say. The High Court judgment and order, the court will find in paragraph 290, the order's in 293. And the judgment starts in that bundle. So 293 is the order, and page 251 is the judgment.
That's the leave to appeal
That's a
order.
leave to appeal.
So
The judgment starts at 051.
oh yes, oh, sorry, that's the leave to appeal petition.
Yes.
Sorry, the judgment of the High Court. Let me just, is on page
Order is 268.
268, which is just after. I just wanted to make sure I'm right here. On 268 is the judgment, that's correct, and that just follows the judgment. And on 268,
It's the order.
the order, yes, that's right. It's the same proposition as the leave to appeal in the other order, but it's important that this proposition is made. It is ordered that one, and there's only one order, the application is dismissed with costs, full stop. However, in the judgment itself, on page 260, there's reference to an objection made by, I can't remember whether it was the police or Home Affairs. Yes, this is what happened.
Yes.
It wasn't the police, it was Home Affairs. Home Affairs objected to certain averments in the replying affidavit. In the judgment itself, on page 260, paragraphs 23 and 24, there's a suggestion that the evidence does not appear in the founding affidavit is prejudicial, etc., and therefore it was hereby struck out. And there's no order to that effect, other than contained in the judgment itself. I have to accept that. But it seems to me that nobody has objected, including Home Affairs, because they were party to the development of the record. So were the police. The police have not objected, it's done by agreement. In the replying affidavit, there are numerous references, which are, by the way, there are numerous references to annexures. The annexures are not attached in the record.
Mr. Kass, I'm going to have to ask you,
Sorry.
what point are you making now?
I'm making this point, that the facts that the court will take into consideration include the facts that are contained in the record in the replying affidavit. Other than the annexures, you have to exclude the annexures. They're not part of the record because they were struck out. I have to accept that. Even though there's no order to that effect in the actual order. So there's no order to the effect that the facts, there's no order to the effect that the annexures to the replying affidavit are struck out.
No.
There's no order. So technically speaking, it could be argued that they should be there. But we haven't seized on that point from a what's the word, a cynical perspective and included them because an order wasn't made. What we have done is allowed the replying affidavit's contents, which include issues such as, on page 223 at paragraph 25, the Minister of Police explained how the arrest occurred. When? 8 April. The police tell us.
Sorry, Mr. Are you not arguing the new point now?
No, I'm making a point.
It doesn't arise out of the reply.
It does.
Out of the
we submit that it does because what
correspondence argument.
The police say the following. It's a very simple case. This is what they say.
Yes.
But they ignore it completely, and we say this court can't ignore what is said about what they say. If they had said, this is what we say, and this is the response, and this is why the response is wrong, context, or whatever, different story, but they don't do that. They say, this is what we say, full stop. We say, we submit. Bearing in mind is what is said about what they say, objective facts. The court will not ignore those objective facts. It can't. It's given a full answer to what they say, and the court can't just ignore it. So they say, let's say for example, they say the moon is blue, and they say that end of the classical level. Let's assume they say that. But in the replying affidavit, we say, no, you say the moon is blue, but look, here's a photograph of a green moon. The court can't just say, well, the moon is blue as a fact. The court would have to say, well, what does this replying affidavit mean? That's the point that we make. You'd have to take into account what he said in the replying affidavit, a la Scott's JA, and all the cases. And again, I come back to Scott's JA must be seen in the light of what he said in Zealand. And we disagree with the proposition that Justice Corbyn put to our learned friend in that you have to go further in the Raven Decatio, because what Langa CJ says is that, no, you don't have to go that extra step. In the Raven Decatio, you've got to say, I'm the owner, and that person is in possession. And he says, the way I read the paragraph after the Raven Decatio reference, you don't have to make that extra step. That's how I read it. That's pleasing.
Thank you very much for the manner in which you've argued this matter. It's not an easy one. The court will consider, and the judgment is reserved. Thank you, the court adjourns.